48 and 80.
Yes, sir.
4 weeks.
You are for?
I'm representing Mother petition.
Good, sir. We'll see. Yes, sir.
Page 5, item 57 to 72.
46, sir. Yes, sir. Infectious. We'll see.
59. And for 2 weeks.
59, sir. Any interim order? We'll see. Please wait for some time. We'll grant it. Please wait for some time.
Extension of the
59? You want it done, but yes.
Item number 67.
1 second, sir. Yes, item 59. List after 2 weeks. Yes, sir.
Number 57.
Yes, sir. You are for GP for? Item 67, huh?
Yes,
Yes, sir. What is it?
only 2 weeks. Serious threat of because
2 weeks in. New petition, 3 days threat now, 2 weeks at now. You'll see. Wait for some time. Yes, sir. I will grant you wait for some time.
Page 6, item 73 to 89.
3 days threat node, ipude argue chestadu. After 2 weeks enti. Ade
Your
chepparu.
Lordship,
Yes, sir. Yes, Mr. Will. Yes.
Your Lordship, item number 86, Your Lordship.
Yes, sir.
The matter may be posted after 2 weeks, Your Lordship.
Yes, sir. The request of the constable patient. List after 2 weeks. Yes, sir.
Obliged.
Page
75.
Yes, madam.
2 weeks time we are already.
Yes, after 2 weeks.
Page 7, item 90 to 101. Page 8, item 102 to 120.
Yes, sir.
In my room.
Yes. 115. Yes.
Get in touch.
Your Lordship, item number 106.
Sometimes once we contact it.
Yes, yes. Yes, 106.
Yes, Your Lordship, item number 106 has become infructuous.
But it's last found it was approved by the council for the petitions. Yes. Yes, sir.
Obliged, Your
Page 9, item 121 to 128.
Yes, sir.
Out of information.
Yes, this one successful with that.
Next week. ఒక్క నిమిషం నేను ఎక్కడికి పోను ఒకరి తర్వాత ఒకరు చెప్పండి సార్ ప్లీజ్ చెప్పండి when do you want sir next week yes sir
This is the matter of the electricity matter. The petition is, I think it is 1 month. Actually, having tomorrow.
day after tomorrow
It's matter mother basing on the vacancy, basing on the increase mother the
Friday yes sir yes
Item 1 for pronouncement of judgment. P. Satyamantala L. Prabhakar Reddy.
yes sir the may may dismiss yes sir
Item 2. Totally is Ravi Prasad.
dismissed
Item 3 is Prabhakar Reddy. Ali Farooq.
enhancement to 2 lakhs 84 to 10 lakhs 500 7.5
Item 4 V. Rajashekar Reddy. P. Satyamantala.
55,000 to 92,000 is the rate of 7.5
Item 5 C. H. Janardhan Reddy.
2 lakhs 73 to 7 lakhs 94,800 6.
Sridhar is Srinivas Reddy.
Be allowed. Yes, sir.
Item 7 T. Suryakiran Reddy. K. Karnasagar.
Please narrow down. 30% of back payers.
Item 8P Govindaraju to Srinivas.
Excuse me, is there some variations in so far as the dates are concerned? Please verify at lunchtime. Go through this data at lunchtime, not now. Some slight date differences. Yes, sir.
Item 9.
1 second. Yes, sir. Writ petition allowed having respond corporate to regular service of the petition with from so and so. Yes, sir.
Item 9 G Ravi Mohan.
Yes, sir. Partly allowed affording the award instead of the petitions continuously without monetary benefits, sir. Yes, sir. Yes, madam.
Item 10 Thakur Rupai Singh.
Yes, madam. Yes, madam. Input the municipality as a party respondent. Included where is GHMC? What is it? What is it, ma?
They have to make a party in this.
అదే చేశారు అదే చేసింది ఇప్పుడు మేడం so far as this proceedings dated 16th page number 16 wherein you have to undertake that the building is above 100 meters, you have to get the occupancy certificate from the concerned authorities. No details, madam, what happened? Yes,
They will verify all our documents. If they want, give us.
ఏ డాక్యుమెంట్ చేశారు వాళ్ళ దగ్గర మీరు?
Whatever they want, you give them.
అగ్రిమెంట్ ఆఫ్ సేల్ వేశారు, ఇంకేం వేశారు?
Processing కోసమే అడుగుతున్నాం సార్ మేము.
It is under article 2 notice is concerned. Number 1, you have to establish a right so far as your case is concerned. I am not disputing that. Yes, I agree and appreciate your argument, but you need some certificate from the fire service authorities as well as the municipal corporation. Simply filing a representation, there is no document has been filed along with the petition. Only agreement of sale. Where is building permission, madam? How many floors you have constructed? No details.
From the state authority, we proceeded. I'm only asking to the extent of.
అంటే ఎనర్జీ డిపార్ట్మెంట్ తప్ప హైకోర్టు అడిగి చెప్పరా మీరు? వాట్ ఇస్ మేడం?
Only processing stage లో ఉంది కాబట్టి we are asking only to process.
Processing means
They, whatever the document they ask to submit over there, if they want to give the LCD or otherwise they will reject it. So only processing are the request. And appear this court in all the, since many years, same what has been asking. The request.
madam, 150 square yards you have constructed 9, you want 9 domestic corrections. That itself shows that it's a
And we having some 4-5 marriage, every room one is. We repair it for combined family, so they will.
9 domestic connections 150 గజాల స్థలంలో.
పెద్దగా కొనుక్కోలేని పరిస్థితి సార్, చిన్నగా రూమ్ కట్టుకొని ఉంటారు కాబట్టి we are asking for them.
You get instructions and file the photographs also. This day after tomorrow. We'll consider day after tomorrow. All matters?
Yes, yes.
All matters, yes. Yes, day after tomorrow. Yes. You file, please file your photographs also. File photographs also, madam, the building photographs in all matters. Not even the across the link. What the matters then? 10, 11, 12, 13, 14. Yes, madam. 16, 17. Yes, madam.
Yes, yes. All right.
Complete petition.
Process ఏ అడుగుతాను.
Complete petition.
Implementation order. ఇస్తాను డిస్పోజ్ ఆఫ్ చేద్దాం ముందు నేను గోతో అవుతాను. Yes. What are the rest of the matters? Oh, it's fresh matter. 25, 26, 27 also.
Yeah.
JSFC party చేశారా? Yes, madam. All matters.
Community engagement చేస్తాం.
Print the name of so and so for JHMC. Shoot మొత్తం.
Next matter, sir.
25,
Party చేస్తాం.
20.
Certain copies also will.
25, 26, 27, 28, 29. 30 also. 32 also. Yes, sir. Yes. Energy.
issue with regard to National Highway Authority.
Yes,
Carrying out the work.
yes, sir.
Whatever estimate required, it has been given to National Highway Authority. They'll have to carry out the work, not doing. In fact, as of today, the service connection is there to the petitioner. They are running.
It's for National Highway Authority, NHAI. Yes, sir, what is it?
Yes, but the electricity is a problem, there's no impediment. We have taken the.
Indian model is there. Find out some solutions, sir.
No, but the issue is, the National Highway Authority was carrying out the work. They asked us to give an estimate for shifting of that particular ST DTR. We have given it. It is for the National Highway Authority to carry out the work. If anything goes below that, it is, we have nothing to do with the shifting of DTR.
Yes, sir, what is it?
Everything composite estimate has been given to the National Highway Authority.
Get some instructions to solve the problem. When you want. Second adjournment, sir. Yes, sir. List on 16, sir. Huh? Find out some solution. Yes, sir. You are for the fifth respond. Yes, sir. Your name is there. P. Harnath Gupta. Harnath Gupta, SC for TTD the question of the HIGCOURT రావాలి. National Highway Authority of India. HIGCOURT. Yes, sir. Yes.
Item 18, Mohammed Mohinuddin Ahmed Qadri.
Yes, sir.
Layout of the tree and third party complaint.
Legal layout or illegal layout? Yes, sir. What is it? This is the first time?
Yes.
Get instruction day after tomorrow.
When I got instruction saying that, then the other person who applied for the service connection by submitting the documents. Whether it appears, then we have released the connection. We have installed the transformer also. After that, when the petitioner has approached, it appeared that petitioner and some third party who was not before the honorable court, they are the partners. There is some dispute between the partners. But your lordship may kindly visualize. Road has been laid. Poles has been erected. Transformer has been installed. Till then, the petition did not wake up. And show that there is some dispute. It is not all of a sudden we have given connection to one house.
It is released for the petitioner, not for third party.
Let the third party respond. He is the third party.
No.
That man should be made party.
No grievance in the third party. He raising some third party complaints in there.
But I have distributed the documents or
Day after tomorrow, sir. Request of the
Whatever
constable. Jack and list day after tomorrow and motion list. Yes, sir.
item 19. Awesome movie GP for energy.
Day after tomorrow. Day after tomorrow, instruction is again the go.
Additional load.
Additional load service connection. Day after tomorrow. Tomorrow, day after tomorrow, listening day after tomorrow, the request of the council for respondents. Print the name of so and so. Standing council, are we know the ready? Print the name of the respondent.
Item 20, Chella Bulletin.
Yes.
Yes, but in similar matter.
Yes, sir. What is it? Same order, page number 75.
Amounts.
Amounts, yes, sir.
The principal amount is 38 lakh.
Yes, sir.
320.
You transcript.
Yes.
It's the same order at page number 75.
50% of the principal is directed to the.
Yes. In లెక్కల్లో బాగా వీక్ చెప్పకండి.
Item 21, C. Bhanu Prakash, GP for money.
Yes, sir.
His period is sustainable.
Yes, sir.
But without any written orders, Milord, the respondents.
Morning operation, sir.
Interfering.
Yes, GP.
They are stopping the operation.
Not into the theory operation petition. That's also. Yes, sir. Yes.
The third party Milord is claiming Milord in respect of survey number 75 Milord. That will see.
The last occasion this matter was studied. Yes, sir. DP for revenue. You have to say. Have you passed on to that respondents? Yes, sir. What is the stand of the revenue? Verify. Sir, pass over. Pass over. What do you want?
Lord, in this case, Lord, I'm claiming the land in survey number 75 of Rameshwara Manda, Patanchari Mandal. Lord, the writ petitioner is claiming the land in survey number 285, Kodakanchi village, Lord, with regard to the Jennara Mandal. Lord, my land is overlapping to the survey number of 285. Lord, basing on my representation, Lord, they pass an impugned order, questioning the same writ petition. Lord, basing on the direction of the honorable court, Lord, they will conduct the survey, appointing the deputy inspector. He filed a report. Lord, despite the report, Lord, the writ petitioner tried to extract the land and minerals from my land. Then, Lord, I filed a writ petition, Lord, 26585. Lord, there was a direction from the Honorable Court directing the authorities not that third parties not to extract any sand and minerals from the land of the writ petitioner, that is survey number 75. When my land is overlapping with survey number 285, Lord, it's primary duty cast upon the revenue authorities and survey land records over there to fix the boundaries. Once the boundaries are fixed, Lord, whether he is in my land or in their land, Lord, it's my patta land. The government does not have any right to accord any permission to the third parties to extract the minerals from my land.
Yes, sir. There was interim order. What is the page number 45?
Survey number 2, that's in that order. In the survey number which I am playing, is entirely different. Let's see, I'm passing the order. Third party, changing survey number 75.
They are saying that overlapping, sir. That is the problem.
But whatever it is the duty of the government.
Yes, madam.
Pass appropriate order without passing appropriate order. What are you interfering? I'm saying this court not to interfere without accordance to law. That's basically similar circumstances.
Survey number is now. That page number that with regard to the land. Overlap, my land is overlapping that one. Page number 40, report given by the deputy inspector.
Similar circumstances, this court will pass not to interfere without any procedure. Now, if there is anything overlap or anything,
Sir, this is in respect of the official respondents, and now the unofficial respondent come and say that the survey number.
Is not party here.
Oh, you have five. Without making him as a party respondents.
He is not interfering. Only government is interfering. My prayer is.
They are saying that you are entering into the land of the unofficial respondent.
No, his survey
Say.
He's entering my
survey number is 75. My survey number is 285.
one submission. Sorry,
Where is the question of we interfering in their property?
he's referring my order.
Location also different. Let me see the order copy. Let me see the order. Page number.
Then why he come before the Honorable Court when he's not interfering over there? He's not filing
Even in this case, even without making my point, update this order.
అతను మిమ్మల్ని పార్టీ చేయలేదని మీరు అతను పార్టీ చేయకుండా చేశారు హైకోర్టు.
Only government is saying that.
He is saying that you are overlapping the
No,
unofficial respondent.
survey number location is entirely different. Let me see, observe the location of Miller. He filed my schedule of property, and his schedule of property is entirely different. Location, survey number, everything different.
What are the instructions?
One simply the same, Miller.
Pass over.
They are saying, Miller.
Pass over.
I will read.
Pass over, sir. Revenue GP.
Connect the parts of the bundle with regard to the QC to it and the bundle.
So the case is tomorrow. Post Telangana so and so. In the morning minister. Number 1.
And
Yes, sir.
Post along with Miller. Both along with this
Section 22.
direct in to list the other disputation.
సార్ అదే చెప్పాము సార్, మీరు టెన్షన్ పడకండి, అది వస్తుంది రేపు.
Item 22, ఈ సత్యనారాయణ బాబు.
Yes, చంద్రబాబు గారు.
The petition challenging the GO investment number 53 dated 9/10/23. The article is page 48 for comment.
Yes, sir. Page
48 minutes.
Yes, sir.
Para 30. Para 13 minutes. May I read minutes?
Para 13.
Yes, minute.
Yes, sir.
UMS number internal page 9, running page 48.
Yes, sir.
The Tahsildar Chandrakunda by the letters also has reported that notice has been served to the second petition, that is Azmira Raghav, my father Miller. Azmira Raghav died now Miller. And notice served to the respondent, Banu Ganeshik's respondent, and served copy submitted. With regard to Google the respondent number 5, he has refused to take notice and also objected to take the notice only. Case finally called. Case is posted to 711 for service of notice to the respondent number 5, who is the sole legal heir of respondent number 5. Counsel for both original petitioner and respondent present. Respondent the Banu Ganesh present. Three Mr. souls are even present. With regard, counsel for respondent Banu Ganesh paid for time for submission of written argument. Time granted counsel. This is dated 7/11. Now, after 3 years, present PO is passed without receiving any notice or without hearing of the original petition. Now, my lord, the original petitioner, Azmira Raghav, father of the petitioner, died on 13/4/21. This is, my lord, 7/11, without noticing, without hearing, my
For admission, we count with the respondent to take permitted to take out personal notice on the unambiguous response. GP for social will take out notice on behalf of the government.
they reflect back to the government because without hearing, that's what the result is. My portion for artists, my lord, also be disposed of. Only on sole no.
Against the
Immediate went against that person.
Yes.
13/4/21 he died.
ఎందుకు అందరికీ కలగొడతా ఎప్పుడు చచ్చిపోయామని. List after 2 weeks, take out notice will say.
Yes, ma'am. My amount of which they included up that is so. You have to suspend the GO because GO itself is illegal. Against the suspend the GO, my lord.
Without suspension as per. Yes,
I know it.
yes. Is the body safe, ma?
Your lordship, kindly have next week, your lordship has taken allotment order is not given. Regarding the tender, your lordship, for the security personnel. Commissioner was, still has L1, your lordship, as per the case. L2, your lordship, L1 was the disqualified, so L2. This
With the case procedure ఏంటి? With the case procedure ఏంటి? L1 రాలేదు కదా, నెక్స్ట్ L2 కి ఇస్తారా? గ్రాంటెడా? ఇచ్చారా వాళ్ళకి? పేపర్ సర్వ్ చేశారా? Yes, ma.
Your lordship, still the allotment order is not given, your lordship. That is the decline to the representation which we submitted, your lordship. As per the hearing office. And to allot the work order, your lordship. Prayers second.
వాళ్ళు చెప్పారు కదమ్మా, వాళ్ళు చెప్పారు కదా ప్రొసీడింగ్స్ లో.
In that, it is stated that they will consider, your lordship. Kindly and after 1 week, your lordship, I confirm with the client and I let you know, your lordship.
ఇది మీరు కూడా అడిగింది అంటే కన్సిడర్ ది రిప్రజెంటేషన్ ఆఫ్ ది పిటిషన్ కదా, కన్సిడర్ చేస్తాం అన్నారు కదా. అట్ ది రిక్వెస్ట్ ఆఫ్ ది కౌన్సిల్ ఫర్ ద పిటిషన్ ఇట్స్ ఆన్ మండే ట్యూస్డే. yes ma.
Item 24, 8, GP for admission.
Let's and pass over minutes. Get up because she's just my daughter pass over minutes. She's on his legs minutes.
ఇద్దరు మాట ఇచ్చారు సార్. లిస్ట్ ఆఫ్ 2 weeks. List out 2 weeks. Request of the council for the petitions. ఇంటర్ మాట ఉంది సార్, నవ్వండి అలా పెడతారు ఫేసు. ఇంటర్ మాట ఉంది అందులో. Yes, sir. Copy of the proceedings to the council for the respondents. Yes, sir. For the petitions.
Yes, yes.
None appeal for the petition. List after two. Yes, sir.
Item 33, Teamwork the digital industry.
Yes, sir. Yes, sir.
Action of the respondent.
Lordship, kindly pass over your lordship.
Yes, sir.
Item 31. Am I audible?
Item 31 now.
Yes, your lordship. Kindly pass over your lordship. Senior counsel C. Raghu sir is appearing.
ఇంటర్ మాట ఉంది కదా లేదా?
He argued this matter yesterday, your lordship.
Yes, sir.
May I please your lordship?
Yes, possible.
Oblige your lordship. 31.
Yes, sir.
To declare the order dated 11/9/2022 issued the respondent 3 refused to conduct the resurvey of the land and asking me to pay the amount without ascertaining as to what is the exact amount which is to be paid. Not the jurisdiction before lordship law is an occupation of industrial law, but the government laid down a policy saying that the occupation will be regularized and a certain amount is to be paid in terms of the G. And petitioner is ready to pay that money, but his grievance is not the actual land which is in his possession. It was wrongly measured, so that the resurvey has to be done. Two representations were made, they were not considered. Then the petition was filed before the Supreme Court earlier. A direction was given by the Supreme Court directing them to consider the representation appropriate. But now again they came up with the possible similar order, saying that this survey would be done after you pay the sale consideration. It's not a question of payment of sale consideration, I'm ready. But unless the land is ascertained, the quantum of amount cannot be ascertained.
వాళ్ళు ఇస్తారు తిరిగి ఎక్సెస్ పే చేసి ఇస్తారు సార్ వాళ్ళు. వాళ్ళకి పోతారు.
But I have to mobilize such a huge funds, I am a small entrepreneur. I have to raise those funds, it is very difficult for me. But therefore, if the survey is done, see what is the harm the government would, the response would have, if the survey is done, the land is ascertained, then they call upon me to pay, make that payment, I would make that payment.
Oh, that matter 300, 200%.
Yes, taken up on 23rd. All other matters
Connected batch is there.
Those matters, the issue was they are challenging the Jew. I am not challenging the Jew in this one. I have not questioned the Jew in my matter.
Even the
Now,
enhancement has been posted on the same day.
Enhancement also I am not questioning here. I am saying I will act as per the Jew only. In my case, only the survey is to be done. The interior order which I am asking is, survey is to be done.
They are ready to pay the amount, sir. Advocate General Office, they are ready to pay the amount.
Yes.
ఇప్పుడు 2933 స్క్వేర్ యార్డ్స్ అని మీరు అంటున్నారు. డబ్బులు పే చేసినాక అది 1700 ఉంటే అది ఆయన ప్రాబ్లం కదా.
I can question, not like
Just 3 matters. WP 24374 2709. No, appeal is one appeal, and other 2 WPs have been posted on 23rd.
this is totally different. I am only seeing the resurvey. I am not
Perspective
suspecting.
of the land at measuring so and so. What is your problem? He is ready to willing to pay the amount
Meanwhile, I said
tomorrow. The request of the advocate office this tomorrow. The portal to the mobile.
But the harassment Jackie will be vanished. Right.
The petitioner. Already complete.
Infrastructure, sir. There are infrastructure determined by the government. The petition does not say that it will be. According to this, is infrastructure. Yes. Yes, sir.
Item 35 and mark your repeat.
Yes, sir.
Respondent.
One second. Tender, so.
Attendance.
It seemed that the notification itself. The requisition has been declaring the action of second respondent calling tenders to through notification dated 23/6/2011. Mr. Chairman. వచ్చేసాడు 2014 ఏదో శుభ్రం చేయడం కోసం అన్నారు ఇంకేముండదు నోటిఫికేషన్ అన్నారు the name of 18 months I think it is a view of several it may have been challenging the external response calling it
Yes. Transport.
notifications of the project that is not service event. Yes, sir.
He really ready and must be ready.
It seems that the current is not service available. Just yes, sir.
Second 39, he remember Pani, one of
But it is different by cost for the respond or we know that it's everything of our move from service. Are we know that it's one of it.
EV knowledge in problem.
And for the petitioner, it is extreme principle. They did not for it talks that they have to
ఇదేం జరగట్లేదు, ఆగండి నిమిషం ప్రశాంతంగా కూడా చెప్పండి. లిస్ట్ ఆఫ్ 2 weeks ఫైన్ కౌంటర్ దీని ఏమో ఆర్ వినోద్ రెడ్డి. Yes, sir. Power supply. think that the government would not service. Strong amount was granted by this court. మీరు అనుకుంటా చూసుకోండి సార్, ఇది ఆర్ వినోద్ రెడ్డి చూడండి, ఫైల్ చూడండి మీరే సార్. ఇంకొచ్చు సార్ అదే సార్ సార్ sir. Feasibility said informal petition extension of power supply also found. Yes, sir. What is it? Under the name of Sri Jackie Adi Danish, the request for the council for the petition to verify whether the charge equipment server. Yes.
Item 43 K gain model.
By the council for the petition, the matter become insurance. Yes, RTC. Yes.
Item 44 Chella Gundanjan.
Sir, what is it? The request for the council.
230 minutes.
The request of the council for the respondents to verify the cause in the explanation. List after 21. 2 weeks. List after 10 days. What is the name of Arvin? We have response. Yes, sir.
45 K Babu will collaborate. Three matters.
When?
29358 of 2000.
When do you want?
Same, they have challenged the same target.
When do you want, sir?
After 2 weeks.
List after 10 days finally. The request of the.
Notice the one which is mentioned is listed today here.
Even these are connecting. 29358.
Because where is those?
Yes, sir. The request of the council for the respondents. Office of the Brigadier General. List after 10 days. The final counter. Counter finally.
2 weeks.
నాకు 2 weeks అనే పదం నచ్చండి, మీరు ఏమనుకోకండి. మొత్తం ప్రోగ్రామింగ్ చేయబడతాం 3 weeks, 4 weeks, 8 weeks. 11 రోజులు అడగండి, వినడానికి బాగుంటుంది. 2 weeks అనకండి.
Item 46 is adjourned. Item 46 GP for 46 minutes.
Yes, sir. Yes, sir. Adjourn అయిందండి. Yes, sir. Yes, sir.
Not adjourned.
Item 47.
ఏమైంది?
46 చెప్పారు కానీ when the list reaches I will tell on.
46 ఇద్దరు 46 ఏమైంది? ఎవరు ఏంటది 46 ఏంటి? Yes, sir. This is woman on it.
47 came from the
Yes, sir. This one, na? Yes. Effective, sir? Yes. By the council for the keep it for industries. Regarding these sources. Yes, sir.
Item 48 is adjourned. Item 49 CH Vidya Sagar.
Yes, sir. In purchase ఇది Senior causing the not survives. Dismissed as a purchase. Yes, ma'am. The individuals are responsible. Southern Power Distribution Company. Vinod verify చేయండి ఇది ఉందో లేదో చూద్దాం స్టార్ట్ పవర్ చూడండి వెరిఫై చేసి పర్చేస్ స్టార్ట్ పవర్ చేస్తాం దీని ఏమో yes yes వెంకటరెడ్డి
Item 50 in interpreted. Item is notice from order the name December 2014 million.
yes sir
The people is guarantor for this date. The respondents over 5 minutes obtain a loan of 3.2 crores.
yes sir
Respondent state financial corporation. Thereafter, the HIGHCOURT issue notice. Page 24.
Rajendra Information Surveys.
Yes,
is the page number?
Page number 24. Sir.
Yes. Yes, sir.
24 dated 7th May 2014. May 8.
Yes, sir.
This notice was issued to the borrower who has obtained loan of 3.2 crores from the HIGHCOURT. This you are amended. These all come sale notice.
Yes, sir.
In view of the above, we are taking steps for recovery of the amount of 3 crores from them. Which is outstanding in your account with interest from 1st May 2014 and others. Amount eligible.
Yes, what is wrong in this?
But thereafter, there are no steps taken by the HFC. Because property has covered. Let us security given as well.
No interim order.
You are notice before it is order.
Sir, what is? You are for the respondent? Sir, what is it?
We have not initiated any action against the foreign secretary. So for this property.
Yes, what is it?
These properties are mortgage.
They are saying that they are not going to initiate any action against you. What is your agreement?
Really initiate that property they must have taken. They also paid some amount.
అందులో సరిపోతే మీ మీదకి వస్తారు కదా మరి అదేగా సెకండ్ వన్ చదవండి outstanding will proceed against you joint claims ever recover the outstanding and so also provisions are listed. Yes sir.
And especially when it is document direct the function respondent to the release. Because my properties are necessarily.
Have you filed any counter sir?
No problem. I will find out latest position.
It is position day after tomorrow. Warangal?
I
Day after tomorrow. Yes. Friday because of the council for the respondents. Good name sir. Yes sir. With day after tomorrow.
Yes.
Get instructions. The present status in the case. Yes sir.
Item 15 and Ram Prasad.
Yes sir. They are saying that they want to withdraw the writ petition sir. ఇది మరి చూస్తున్నారు replacement of the withdraw the writ petition 40428. None appear for the petitions. List tomorrow for discussion. Yes. This for the respondents. Yes, sir. Southern Power TSHCPDCL. Mirana, what is the name of Vinod Reddy? List tomorrow for dismissal. None appear for the petition. Day after tomorrow, I will verify. Yes, sir. NPDCL. What is the name of Jakir Ali Danish? Yes, ma'am. Anything survives? Anything survives, ma? 2014. Jakir Ali Danish. What is the name of Jakir Ali Danish? The place of songs for the respondents. List on Tuesday will verify. Please inform me about it. Yes.
For the fiscal caption, item 53, who must discuss the lawyers.
Yes, sir. Yes, sir.
Very often the paper was pardoned for not being present on the teaching petition. I was on my next from first court to this court.
Yes, sir.
This is a expedition filed in 2016 with respect to a approved project for which land alienation proposals were rejected by the district collector. On the previous occasion, at least last 3 occasions, the government created for revenues sought time for filing counter.
Yes, sir. Yes, madam.
GP for industries has filed the counter. GP for revenue wanted to file the counter, and for that the matter was adjourned.
Yes, madam.
And the land was being, land topography was being altered, so I thought for interim order.
Granted, status quo granted. What is ma'am?
They are busy with elections.
2016 నుంచి బిజీగానే ఉన్నారు కదా.
The application is
అదేనమ్మా రండి. Again into 2016. Yes, sir.
Item 54 and 55 in
230. Will hear you. 230. Pratik Reddy. Pass over. Yes, sir.
56, G. Pramod Kumar.
Yes, sir.
Item 56, G. Pramod Kumar.
NPDCL, sir. Jackie for respond number 2. Who is for regulatory commission? Power regulatory commission. Ashwin Kumar, so for the power respondent. This next week, Thursday. None of you for the petitioners. Yes, sir.
Item 57, G. Matsudar Reddy.
Yes, sir.
Interfering into the output of the petition with the following process. And the petition for the property registered sale deed page number 11. The petition comes in the page number 39. The plot in the project code affecting all of the views are page number 38.
Beautiful social.
Page 39. 40 plot number 17 and 28. Number 41 the before direction
GP, verify. Day after tomorrow. What is it?
There is point stating that the subject property is different from the subject property.
Very good. I will hear you. When do you want? Thursday. The request of the council for the petition as well as respondents for a hearing. List on 17th, 17th. Yes, sir.
Item 59.
Yes, sir.
Appearing on behalf of the respondent number 3, official respondent number 3, this request. I have filed my budget application.
Which one, sir?
I have 59.
59.
2 weeks.
Without informing you,
Yes.
list tomorrow.
Item 60 in Hariprasad Jafirali Dance.
What is the response?
Yes, sir. And you have none appeal for petitions. This chapter, yes, sir. 22nd. Yes, sir.
Item 61.
None appeal for the petition. Any interim order granted by? Yes. Complied. Interim order has been complied. Nothing survives? Not survives. Maybe they posted for dismissal. Oh, already you have given connection. Huh? None appeal for the petition is tomorrow for dismissal. It is the name of Karuna, sir. It is 61. It is the name of Vinod Reddy. Item 61 hai kada? Yes.
Item 62, Mayur Mitra, GP for answer.
Yes, sir. 2 weeks prior to the request of the council for respond Vinod Reddy. So, stop to 2 weeks. The name of Vinod Reddy. Yes, sir. Yes, sir. Yes, AG office. I'm happy for the petitioners. List after one.
64. Ishwarji, S.V. Ramana.
Yes, madam.
Is 5 million.
Interim direction is there. The request of the council.
The option response needs to file a counter.
What do you want, sir?
Petition.
2 weeks ఇందాకే చెప్పే కదా అవద్దు. పెట్టింది ఈరోజు 14th కి వేస్తాను వేసే. రిక్వెస్ట్ ఆఫ్ ది కౌన్సిల్ రెస్పాండ్ Vinod.
Stay was extra long back. You lost.
స్వామి కొంచెం శాంతంగా ఉండాలి. మీరు బాగా ధరించారు. Extended up to 21st. List on 15th.
Monday week, because 14 may not be available. Monday week.
20th. Next week is సెలవు కదా సార్.
I'm mobilized. 20th to last.
In the meantime, we try. Vinod Reddy.
Item 65, H. Again, GP for answer.
Yes, sir. Request of the council for respond. Yes. After 3 weeks. Yes, sir.
Item 66, Srinivas, GP for votes and values.
Status yes, sir. None appeal for the petitions. Yes, none appeal for the respond. The petitions. List on 28th. Yes, ma'am. Yes, sir.
Yes, my lord. Please, counter scheduled area. Strangely, scheduled drive is being evicted on the name of non-scheduled. The NTR is in house part petition house pattas are granted with non-scheduled drives, which is illegal as your lordship knows. The NTR case is pending. Notice was also issued. While the NTR case is pending on the
Any interim order granted by this court?
My words, my lord.
Clearly observed to not restrain their hands. Till now, they
My lord, they are the land grabbers, my lord. Kindly give the time to file the counter, my lord.
Yes, sir.
will happen, my lordship. Not
They are the land grabbers, my lord. Kindly give the time to file the counter, my lord. They are not the real owners, my lord. The respondents are the real owners of the land, my lord. That's outside pattas were granted by the government and distributed by the government. They are in the position, my lord.
Since July 4th, this matter was adjourned frequently. What is it? July, August, September, October, November, where?
Kindly give some time, my lord.
No dispute that
Instant final charge, my lord.
request is paid.
You are for
I am for respondents, my lord. Unofficial respondents.
request of the constable, the unofficial respondents. Filing counter. List on 15th finally.
Okay, my lord. Thank you. Obliged, my lord.
The oral tradition of example.
Item 68 L.
నా సజెషన్ ఉంటే ఈ దేశాలు ఇంత వర్క్ రాదు కదా అవన్నీ
They
విధానం
held their hand till now, but there is a danger. They held their hand still now because of the oral. Example for not to participate in that. Only.
ఆ మాట వినగలిగితే ఒకే కుటుంబంలో పుట్టి ముగ్గురు అన్నదమ్ములు ఎంత అనుకుంటారా ఆఫ్రికా
Item 68 L. Ravindra, GP for social welfare.
Yes, sir. Also for counter. Not for the request of the council for the request of government period for social welfare. On payment of 2000. 2 weeks filing counter. మీరు ఉన్నదే అందుకు బతిని అడగండి ఆఫీసర్ నేను అంతకు ముందు కూడా చాలా చేస్తున్నాను రీసెంట్
Item 69.
రీసెంట్
Item 16 is the serious law.
ఎస్ సార్ ఎస్ సార్ request of the council respondent corporation. 21, sir. It's on 23rd. Finally, yes, sir.
Item 70.
In the name of so and so, Arvind Reddy. Yes, sir. Yes, ma'am.
For counter of the respondents, the facts of the case are that into the tender notification, the petitioner didn't.
Otherwise, my tender notification is at page number 18, huh?
Yes, my lords. I was allotted cluster 7, my lords.
Yes.
That consists of 2 routes, wherein after that, in fact, they've stated in their tender notification itself, my lords, that subsequent to the allotment of the tender notification, the petitioners are supposed to approach the financiers and obtain finance, my lords, for flying the buses. And they are supposed to produce the buses within a period of 90 days. As it was not viable and my financiers have denied me to finance for 2 routes, I have approached the corporation once again and made a request, my lord, to grant me only 2 routes instead of those 4 routes. That was considered and a reallotment letter was issued to me. But the respondent here have done, my lords, that they've taken the date, cut-off date as 90 days, because subsequent to the 90 days, my lord, 1,000 rupees per day would be imposed as a penalty on the petitioners. Now they've taken the cut-off date from the earlier allotment letter. And I made a request, my lords, to them to consider my second allotment, re-allotment, because I was in a fix, my lord, whether it would be considered or not, because of which I could not approach anyone.
The petition, none appear for the respondents.
It is coming to counter, my lords.
On 14/7/2020, the request of the council for the respondent corporation, 2/3/16 for filing counter. The direction. List after 1 week. On payment of 2,000 rupees to legal service director by the respondents, yes. Yes, sir.
Item 71 for Amit is released out.
మర్చిపోయింది పేరు రాలేదు ట్వంటీ ది నేమ్ ఆఫ్ తుమ్ శ్రీనివాస్ రావాలి ఫైన్ తీసి మేడం కౌంటర్ ఫైల్
Applied the order.
సర్వీస్ సర్వీస్
Nothing, sir.
governed by the council for the petition. Now the interim order granted on 19/7/2023. Order has implemented. Regarding the same, the college bill does not serve as account victim, which is here. Yes, sir.
Your lordship, I am online, your lordship. I am for petitioner, your lordship.
Yes, sir.
Your lordship, kindly come to page number 14, your lordship.
Yes, sir.
Impute notice. Your lordship, this impute notice is challenged by me, your lordship. Operative portion of impute notice, your lordship, third para. In this regard, you are informed to pay rupees 50 plus 18% DST per pole towards laying of FO cable on TSHC DCL pole. If paid, please submit receipt within 7 days. Otherwise, necessary action will be taken without further notice. Your lordship, this is a fairly covered matter, your lordship. Kindly come to page number 24 and 25, your lordship. In similar circumstances, his lordship Justice K. Sharath passed an interim order, your lordship. Your lordship, operative portion, your lordship, order, page number 25, your lordship. Interim order granted earlier shall stand extended until further orders post on 26/10/2022 for filing counter, your lordship. Your lordship, actually the TSHC has no authority to seek this kind of fee from the petitioner, your lordship.
Yes, sir. And the request of the council to respond on ready. Verify the evidence also. List
Your
on
lordship, interim order may be granted, your lordship.
14, I will pass interim order on 14. They want to verify the order, sir. List on 14 in motion.
Lordship, the covered matter, your lordship. Same subject matter, your lordship. But operator is different, your lordship, therein.
They are disputing it, not a covered matter. They want to verify. For that only, I am adjourning this matter on 14th. In motion, this, sir.
Much obliged, your lordship.
Motion is list on the council to respond. Are we not ready? Which is the name of sounds or I never of them? Yes, sir.
The petitioner is the Labour Cooperative Society consisting of Madras. Way back on 6/7/2009, they have made an application. They were rejected by proceeding the receipt 26/5/2007 on the ground that NOC party could not obtain NOC. The truth of the matter is getting NOC is not the responsible applicant. Actually, what happened, my lord, this area was originally granted by way of a GO in favor of an industry. Setting up it. That GO was subsequently withdrawn. My lord, again, against this rejection, petitioner filed an appeal. Appeal was also rejected on the very same ground. Actually, the area was available. That is the 2000.
Sir, there was a clear finding of the MRO kindly second paragraph. The assistant director finds and here sound. So request is others seeking report category of classification availability of the land is survey. Accordingly, Vinara so report land is not available in subject area. The appreciation of objection certificate. What do you say to this section?
Which paper?
Para number 48, para number 2, 48 page. Yes, sir. What do you say?
Yes, sir. This order was against which appeal is filed.
Appeal also dismissed.
Appeal dismissed on the very same ground. Telling NOC is not the responsibility of the party.
File your counter, madam.
Can you see the memo of the principal secretary at page 18?
Yes, sir. Page 18.
18, exhibit P1. An instance has come to the notice of the government of rejection of our claim for grant of Forley for the receipt of non-receipt of collector's report. Obtaining report of the collector is the responsibility of the department, and therefore rejection of the Forley's appeal on the ground of non-receipt of collector's report is not justified. The director of mines is therefore directed not to reject Forley's appeal on such ground.
Sir, this is 1990s. After that, the policy has been changed. Some of the GOs have been.
Same thing.
Yes, ma. What do you say?
GOs have changed, but the same principles continue. It's a matter of one department and the other department. How do we know? We are not here to pursue between departments. We made an application where.
Yes, what do you say? In July. Counter. What counter is there? Counter ledamma. Rain. Even.
They have
14th. Because of the GP person, mines and industry and farmers. List on 14. For filing counter.
74 G must have been.
Yes, sir. Yes, sir. Production of records.
Committee. Any opportunity of cross-exam the witnesses regarding the statements are recorded behind back of the petition. Not the statements are recorded as exports. No operations were made complete. They lost page number 23 because they are page number 23.
Yes, sir.
Third page.
1 second. వారికి ఇవ్వండి చదువుతారు పేజ్ నెంబర్ 20 చదవండి లోపల చదువుకోండి గట్టిగా చదవండి వారికి ఇవ్వండి
We do not have any witnesses. To obey the institution of this, you can so then it is not requested to continue with the inquiry. Then the petitioner is saying that he has not any witnesses. He is not saying any that Milad is not subject from the election with the fixed court judgment and as well as the Milad the page number will not be missed. Page number 84.
Yes, sir.
These are the Milad procedure how to deal with the circumstances. Page number 84. Page number 86 you will have. Examination of witnesses.
What is your prayer, sir? Main prayer? Kindly
There
read.
is that Milad without issuing any notice.
Kindly read the prayer, sir.
Clearly the actual respondent person submitting the reports goes to the so unfortunately the judge without giving any person to examine the witnesses. Examine the
Main prayer, sir. Yes.
examine the witness and also non-consent explanation needed also as argument illegal violation of this national. Earlier I find the repetition challenging the notice to not report directed to the action in the order passed by this court Milad. Page number 48. Reported page number 4 Milad.
Yes, sir.
Needed to be. The submissions made by the respective parties. Both the petitions are disclosed directly on the conducting
Yes, sir.
inquiry.
Mokalam to issue notice to the petitioner as well as respondent number 3 repeat number so for conduct inquiry reports and so on.
Issue number right, raise all the objections. I raise all the objections. I find the objections will not page number 24, 25, 3, 20, 23. I raise all the objections. None of the objections considered by the commission. Now reference is made. Well,
What is the stage of the criminal?
it's not. They are not recommended to not payment. They are recommended to not say. The recommendations will not change the service.
Where is that?
33 minutes. The Lord should see the findings, page number 31. Thing is discussed, just explaining, not you will ask me to see the findings.
31.
31.
Yes, sir.
Findings of LC. They quoted the sections, not a section, page number 33. Recommendation. LC Hyderabad directed order to
1 lakh.
provide full salary CW1 from 22nd to 22. Okay. Provide CW1 with the expense certificate, a compensation of ₹1 lakh. CW1, 50,000 fine to be paid to LC Hyderabad, rental company not funded in company. I raised the objection. None of the objections was considered. I am not given any opportunity to cross-examine the witnesses of the cross-examine the witnesses. The honorable court, your lordship may see the judgment of the honorable court. Proceed with the page number 90. Sir. Examination of witnesses.
Who is for the
1920.
who is for the habitual respondents?
Outer 5 saying that they did not follow they did not follow the violation of principle. Not bound to follow the principles of nature.
It's a standard, knowledge, the standard that principle of natural justice apply not friendly to a court and an inquiry. That is the stand we have taken. In this case, my lord, the declaration that they have produced before your lordship, that declaration clearly shows two things. One, that he does not wish to examine any witnesses on his own. Second, he says he is aware that the committee is examining the witnesses of the complainant, and he's asking the committee to proceed with that. He's not seeking a right to cross-examine. He's been made aware that the witnesses are being examined. He's not sought any liberty or to put questions to the witnesses. Lordship, we see, apart from the declaration, there is also an email that was sent, my lord, to both parties.
Yes. Statements are recorded in 6-4. The date, there is no notice. Lastly, by the signature made on 12-4, the statements on 25-3. Signature on 24-12-4.
No, in the declaration on 12-4 also, when there is a specific, when he is aware that witnesses are being examined by LC, he ought to have made a request, my lord, that to seek cross-examination of the witnesses. But after the entire process has now been completed, there was never a request made. This honorable court directed the committee in the earlier round of litigation, directed the committee to issue notice and proceed. They have issued a notice, they have called for a reply, they have examined witnesses, they have examined multiple witnesses, and they have passed, given their findings. If they wanted to examine, they were specifically put on notice that witnesses are being examined. They ought to have ask questions, and usually one of the procedure that is followed in such committees, because the witnesses are usually victims and the employer itself is in a dominant position. The procedure that is followed is a questionnaire is shared. The accused would give a questionnaire to the committee would put questions to them. He would not directly put questions to them. That is the procedure followed. But in this case, he has never availed that opportunity. And after the entire inquiry is completed, he's come to this honorable court seeking.
Then let them show one notice, and the date of the statement record. They issue the notice to me. The notices were recorded behind my back of petitioner. Not given an opportunity. We are not issued a notice. We are not aware of whether they are whom their statements are recorded by the authority. The court also will actually let you know.
What is the stage of this criminal complaints? What is the stage?
Complaint and told out that the still had investigation charge.
That criminal case is not that is there issued there. After making the criminal complaint is made, I went up to approach the authorities, the police. They called the player, they responded, she did not turn up. Thereafter, they issued the party.
What is the motive behind the issues of the complaint according to your work? What is the motive?
She is the working with the petitioner, not both are going to Madras, Chennai.
బయటికి చెప్పదు నా మామూలు చెప్పండి సార్ మోటివ్ ఏంటి
Only allegation is that Pinadi misbehaved in the hotel. No statements were recorded for the hotel authorities.
GP social welfare. Who is for the petitioners? Yes, sir. What is it? Any interim order? At the request of the council for the petition. This on 6th December.
77B Venkatesh are
For counterpart, official responsibility.
Yes.
The official respondent file the counter to the
Who has to file counter, ma?
official respondent like if they file the worker.
Any interim order? Yes, sir. What is it?
In additional land, they give the directions to the official respondent lodge. The land belongs to the petition even.
Have you filed proof of the service?
We have already disconnected and it was removed.
Yes, what is it?
Tomorrow I will get instruction whether what happens.
Our material instructions కూడా కావాలిగా. At the request of the council for the petition, list tomorrow to ascertain whether the charging the retribution surveys or not. List tomorrow in motion list.
Much obliged.
Item 78, GP.
Yes, sir.
Item 78, P. Maria, GP for services to.
Yes. Can appeal for the petition. Yes, sir. Which ma? What matter is?
78.
78 yes. GP for services TSHC. Respondents. Yes, GP for minorities. Commission kada, state commission ante valega, minorities kada. Social welfare, minority welfare. Yes, social welfare and minority welfare. GP for services CC. Yes, ma.
Item 79 as Lakshmikant, GP for social welfare.
Respondent who is the Marathi chairman and Marathi district collector of Maratha, Ungud district, identified my building Maratha for the purpose of residential college. Maratha Austral district, Maratha page number 17 is the Maratha order passed by the third respondent. But may kindly come to page number 18. Meanwhile, Maratha, they should not Maratha use that excess amount whatever directed so far. I'm only saying Maratha, let them not be Maratha use that amounts. This is what it counts. So they should not use that. That is only my. The amount is being given to only for the purpose of maintenance. That maintenance is not for that matter only for the society. All the societies are being treated with the same amount. That the Indian Maratha
One thing.
Lordship Maratha.
I will hear you.
Aspect is the same. Given letter, not to use that amount. That is only the Maratha. And if at all they spend that my money, that is Maratha money.
You are before 226, I think.
Even though.
Request of the council for the respondents. This is the matter on 21st for hearing. They have the matter for the other. Yes, could I letter go to this one? Yes, sir.
Item 80.
No status quo, is there any counter filed by the respondents?
Item number 1235, not support to revenue.
Revenue is? Yes, ma. Gettiga Japara. The request of the GP for revenue. When do you want? This on 23rd finally. Yes. Yes, for filing counter, sir. Good for the petitions. Please for the petitions. Anna appeal for the petitions. This on 5th December. File it. Yes, sir.
Item 82.
The piece where covered sort is this on report at page 62 minutes. Lots are here that ascertain the GP2.
Anyhow, in the meantime, responsible right to not to take any courses against you. Yes, ma'am, what do you say?
It may be disposed by in context of similar orders at page 62. Let them reconcile the bills as restored by the respondent authority. As likewise, the appellate authority also passed in a similar line. So that order is at page 48. This court passed order at page 62. It may be disposed to
In respect 2016, find out, verify this, whether it is covered or not. Install Friday.
Earlier, Lordship.
Friday, sir.
Marks.
In the direction not to take any questions. Finally, on 15, find out.
I must say, let it be expanded to the primary.
There was a interim direction not to take any questions. So they are asking for time. After that, also there are suffer adamant more than 3 or 4 times. How can I? Yes, ma'am.
I'm leaving you.
On 16th, yes, sir.
Stay my lords on demand.
Status quo only, sir. Status quo only, sir. Sir, 1 second, sir. For all learned persons, status quo already not to take any course steps. So, get this control wall. Line to Nara, Akara.
Okay, it's not that.
Yes, sir. Yes, sir, 16. Find out, ma'am.
83
Yes, Durga Prasad.
That in this case, the petitioner society sent the tender notification at page 12. Page 12, I read 2-3 lines, let me kindly take page 12. The tender notification issued for raising contract of land excavation.
Yes, madam.
In Godavari River.
Production of records. Yes, Sanjay. Ready? Okay.
This is affecting the Medigata project also in the surroundings within 10 kilometers. The huge excavation of land is affected. Let us find yes, after filing this, that
let me make out a case.
Yes, I will. This court found that there is a prima facie case and granted interim. That is my
vacation.
It's only prima facie.
Yes, that's right. 1 minute I will show what is the difficulty and what is the defect in the tender. Page 12.
Yes.
But when tender notification issues, everything will be crystal clear. Here, mirror. Mirror, page 12. I will read one by one. Approximate value of work 778. Got it? Page 12.
Yes, sir.
Second column, approximate value of work 7 crores 78 lakhs. Tender fee so and so. Bid security. Period of downloading of so and so. Pre-bid queries online. Date 21/9/23.
Date will be informed. That is only your objection, huh?
Price bid open. When price bid will open, date they won't inform. This is the defect in tender. The collector and other officials conducted a public meeting. The report is there. Now they want to conduct the auction without giving to the societies. Here, the land collector report is there. Relevant portion, paragraph page 20. I won't trouble this court.
Yes, sir.
Para 8 onward. Sudhakar Pankana, Society President, after customary welcome address to their people gathered at the venue, public representatives, he requested to hand over the quarry to the local societies. Santosh Pankana, after customary welcome address to the chair, people gathered at venue, public representatives, he requested to disclose details of patta land of 100 acres identified for quarries. The Joint Collector Jayashankar Bhupalapalli district has thanked everyone who contributed to the smooth conduct of the public hearing meeting. She said that the opinions expressed by the public are genuine and needful. The minutes with video of the public meeting will be forwarded to the state level Environmental Impact Assessment Authority, Government of India, for further action. She hopes that the government will take positive decision about this project. She mentioned that there is no permission to TSMDC to carry out mining by mechanical method and she strictly instructed to TSMDC management steps should be taken to ensure that the sand mining is done manually. This will create employment opportunities for the locals at this area. He is very interior and public are hardworking and capable. She directed TSMDC should pay special attention to control overloading of lorries in the district to protect the roads while transportation of lorries, and suggested to alternate route may be choose to avoid inconvenience to the local public. Before concluding the meeting, stated that she directed TSMDC management to provide employment to the local public, keeping the law to public.
Local public, yes.
Now, Miller, they issued the tender notice, provide for somebody, and it is only on paper regarding excavation by manual. Every quarry operated in Telangana state is operating with mechanical mode. Even today, Milord, if we went to see any quarry operated, this is now, Milord, earlier, individuals will operate sand quarries. Now only one agency in the entire state, that is TSMDC. Every newspaper will write sand mafia. Now they won't fight. In this area, Milord, one of the reasons for damage.
Sand mafia.
And machinery is using in every place. It's only IWAS that saying that manual operation. Not even one place where they are not doing manual operation. Everybody is doing only mechanical operation. And this tender, is a defective tender, and it should contain the data also.
Yes, sir.
Price bid bill. I am not agreed by this because this tender is allowed. We will lose our livelihood, Milord. That's why the societies are entitled. In the tribal areas, scheduled areas, there is a specific clause. Here, Milord, this even in the forest area, it is not notified as a scheduled area. That's the difficulty. We are in deep forest area. We are entitled for this society, Milord. That's why I filed with this. That's why kindly consider it.
in the interest. The report of the joint collector is very much clear. And the government, they said, the reasons best known to them, they have now notified this. If it is continued, the entire area will be disturbed and the people will create problem.
రైడర్ కూడా ఇచ్చాడు
That in case we will argue outside, madam.
కాఫీ తాగొచ్చారా?
Great respect, my dear. Yes. None of the submissions which have been made before your lordships for consideration are supported by a single bid. The case of the petitioner is that he is a Krishna Committee Sand and Muram Quarry Labour Contract Mutual Aid and Cooperative Society. This particular society is registered under the Cooperative Societies Act and it is in existence in the non-scheduled area. I heard my friend saying that though it is in the deep forest, it has not been declared as a scheduled area by His Excellency the President. The admitted fact is that it is in non-scheduled. But insofar as the pleadings are concerned, nowhere in it a ground is made out for challenging the tender. Not even a single sentence. The whole of the writ petition order says that they are not having any employment if this particular body is given to this society. They can eke out their livelihood, except that there is nothing. But my respect of submission, everything in this country is governed by law. But insofar as sand mining is also concerned, your lordships are aware. After the state formation, a new sand policy has come into existence by GOMS number 3, dated 8/1/2015, which is at page 26. Your lordship,
metal paper?
Yes, I find along with the data.
Yes, sir.
Page 26.
Yes, sir.
That insofar as the sand mining is concerned, it is three types of mining. One is the mining of the sand from the notified sand bearing areas. That notification will be issued by the district level sand committee. The second type of mining of the sand is the sand accumulated in the bottomlands. That is called decasting. So that the land of the agriculture is, after the sand is decasted, it is fit for agriculture. Then the third type of operations for extraction of sand is desiltation from the reservoirs. These are the three types. But insofar as this particular case is concerned, it is a notified sand bearing area. If notified sand bearing area is in scheduled area, my friend has every right to assert that it should be given to. But if it is not in the scheduled area, it is only the TSHC which will take up the extraction by appointing a raising contractor, by calling for e-procurement tenders. That's what has happened in this case. Can we see page 26 for a second?
Yes, sir. Yes, sir.
Para 2, regulation of extraction of disposal of stream river sand. And meeting Roman 3. Allocation of specified sand bearing areas located partially fully in scheduled areas shall be as per the Panchayat extension to scheduled areas, PESA rules 2011, or any suitable subsequent rules amendment to be issued by government from time to time with technical and administrative support from Telangana Tribal Welfare Authorities. Then, if it is not so, let's kindly see rule 3. Sand extraction in 1 and 2 order streams. Sand extraction should be permitted in notified overexploited areas except for local use in villages or towns, boarding the streams for the bona fide purposes other than commercial, public, stocking, etc. So, then constitution of the sand mining committee, rule 4, at page 29, be your lordship.
Yes, sir.
Telangana State Mineral Development Corporation shall obtain the following statutory clearances. Approved mining plan for the Deputy Director of Mines and Geology. Environmental clearance, can you make a note of it? Environmental clearance from the State Environment Impact Assessment Authority. Consent for establishment and consent for operation.
On submission of statutory clearances, the chairman district level sand committee shall allot the specified sand trading area to TSMDC for extraction of sand. TSMDC shall execute a lease deed in form S1 with assistant director on application filed by TSMDC. The chairman district level sand committee may control the area and so on and so forth. But this is the procedure. But these rules, giving it to TSMDC, are also under challenge before the first court. And my friend has also filed two similar writ petitions challenging the validity of the very same rules. Well, it is an admitted fact. My friend has admitted that it is in non-duty. Well, I have obtained a letter from the district collector in page 77 kindness. An impression was given as if the Grama Panchayat has passed a resolution exercising its power under section 7 of Rule 7 of PESA rules. And this honorable court prima facie felt that this is governed by PESA, this is in scheduled area, stay. It is not correct. So that's what has happened. Kindly see page 77 for a second. Subject is the Rajpur kindly see ITDA Edu Nagar, Jaishankar Bhopalpalli district sand bearing areas identified Pankena 1 and 2 at Pankena village, Palimela Mandal, Jaishankar Bhopalpalli district area allotted to TSMDC and transportation of sand. Agreement made in favor of so and so. WP 260. This is the W. Filed by Lakshmi Deva Tribal Sand and other petitions also filed. And information submitted. I invite kind attention to the reference section. It is to submit that as per the records available in this office, there are no scheduled villages existing in Jaishankar Bhopalpalli district. In this regard, it is submitted and bring to the kind notice of the district collector Jaishankar Bhopalpalli that there are only 3 villages are falling in tribal subplan area, but they are the non-scheduled villages. That too, Kamalapur, Rampur, and Devduputapalli. The Mandal villages which were merged from the erstwhile Telangana district are falling in MADA and TTG areas, and these villages are also not covered under schedule. And I have issued, I have obtained kindly see I have obtained EC in accordance with the EC. I have filed it at page 49 to 60 from the state level impact assessment authority as per the rules. Kindly see at page 49. This is the EC granted for me.
Yes, sir.
Kindly see serial number 6, name of the project. Proposed sand mining over an extent of 19.98 hectares, Godavari River, sand in Pankena village, Parvela Mandal, Jaishankar Bhopalpalli district. Name of the company organization is TSHC. Location of project is correct. Then, the pollution control board, I have obtained CFP at page 61.
Yes, sir.
And CFO at page 66. At this stage, when the notification was issued calling for tenders for appointing a raising contract, but a writ petition is filed saying that we are entitled because there is a Grama Sabha resolution. The Grama Sabha resolution is valid if this village is coming under PESA. Therefore, except saying that there are unemployed youth, please give it to us. There is no right that has been shown to them or to your lordships for consideration. Therefore, there is an urgency in the matter. I have mentioned it before the concerned court also, and after that, during the vacation, it has been listed before you. Therefore, my respect to sufficient writ petition has to be dismissed to the interim order.
Yes, sir.
The certificate will be issued in the name of the company and government only, not for individuals. It is the statutory rule. CFO, CFE, they have to be obtained only because it is a government area.
And your privates are also aware that in Samata in 130, the Honorable Supreme Court said that even if it is in the scheduled area, government cannot do it, but its undertaking can do it. At page 132, that I read it. Of course, this is not in scheduled area at all.
Para 132.
Para 132. I'll just read one sentence. The state government therefore is directed to ensure that all concerned industrialists, be they natural or juristic person, stop forthwith mining operations within the scheduled area, except where the lease has been granted to the state undertaking, that is Andhra Pradesh State Mineral Development Corporation. They should report compliance of the order to the registry of this court. But Samata, your lordships are aware, 1997 Supreme Court, Blood has dealt with blood extensively, including blood who is a person. But this paper blood, assuming that it is in scheduled area, that I am entitled to do it. I am a state undertaking. As said by the Honorable Supreme Court.
But I am not against the TSMDC. Even if I do this, it is under control of the TSMDC. But the TSMDC will collect the money and distribute the money. Only we are the persons to execute the work. Even raising contractor also, he will not collect any money. The money will go straight to the TSMDC account. It will go to state treasury. Then they will spend. Work will be executed by individuals only, either by the society, labor, or the contractor. Here in our case, my lord, we have the area which is totally thickly populated forest area. That's why
Forest to thickly remote అని ఎన్నిసార్లు చెప్తున్నారు అర్థమవుతుందిగా మీకు?
Virat, that's why my friend says they are entitled because these government corporations, they are doing the business. But Virat, the work is done by either by organizations or by the contractors. We are entitled because we are in the area and floods comes, these people will not support us. Godavari river, every year Virat, floods are coming, so much of loss is caused to our properties and lives. TSMDC will not do anything. The joint collector is physically present and found that it is an area where protection has to be given. And when floods are coming, this TSMDC is not giving any support. Just to extract money by selling the sand, doing the business. Now my friend says, Supreme Court judgment, there are several judgments. They will say, this is totally forest area. I'm not blaming Virat, we are doing our service.
I have appeared for 10 years for the sand contractor. There is no difficulty in that.
Virat talking like one quarry Virat operated manually.
My submission,
What may observe?
submission is
The 6 years to grant continue the interim order
being done.
because the tender is defective tender.
This is being done in accordance with law. There is no challenge to the tender, except saying that please give it.
Virat, they have not mentioned the date. Virat, tender has to be clear.
Tender is not under challenge on any account.
Then the court has power to found the defect in the tender.
84 and 85. Yes, sir. What is it?
It is related to singularity policy.
Yes, singularity policy. Yes, sir. They are saying that Patas has been cancelled.
There is an instruction from respondent for
Yes, yes.
papers.
Yes, kindly read it. తీసుకోండి పేపర్ స్వామి తీసుకోండి.
Clearly states.
Yes, sir.
Clearly stated that a decade back, this bag was already given to singularly polished. There is no.
File your counter.
This clearly states that the counter is required. As per my instructions, sir. Fabricated document. Let us check counter. Counter need to be filed.
The request of the counter for the respondents. Singarani alone GB for revenue for filing counter.
GP for filing.
GP for assignment. List on 12th December for filing counters. Both the matters. Yes, sir. 86 ఏమైంది? 86 ఎట్లున్నాయి? Any urgency?
Yeah.
Yes, sir. You filed vacate?
No.
Yes, sir. Anyhow, the interim matter is there. Have you list after 18th December? Interim matter is yeah, 18th December. None appeal for the petition. Yes. 87 mark for filing counter. Is it? 18 December. Yes, sir.
For respondent number 7, I requested for time for filing counter, but your lordship asked the GP to take instructions and come out.
Yes, sir. GP. Emma. When do you want?
My lords, I may be submitted to file a counter.
Yes, today is the request of the council for the respondent number 7 for filing counter list on 21st. I mean, we would have made the counter. So the council correspond as well as GP for indices and mines. Yes, sir.
Item 18 and C, flexibility CP for NMC.
GP for mines and GP. Yes, sir. Yes. Yes, ma'am.
There is a direction memo.
Yes, what is it? The matter is there. Yes, sir. Transmission, Transco.
Yes, ma'am.
Who is for the respondents? Transco. Yes, ma'am. Principal Secretary. Who is for the corporation? TS Transco. The name of R. Vinod Reddy. For Transco. For filing counter list on 27th December. File your count.
GP for general administration.
Yes, GP garu. For the petitions only, yes. Yes, sir.
Last petition was urgent for the instruction, my lordship.
But let's find out. Instructions why.
Meantime, my lordship, so I can tell you relief for that, that is the representation.
All బిజీగా ఉన్నారంటే వాళ్ళది అదే కావాలి చెప్పేది మనకు రిలీఫ్ కావాలి కదా. Let's find out. When do you want? It's a matter of 10 minutes, sir. At the request of the GP for General Administration. AG office. List on 24th of this month.
2 weeks.
Before the other వచ్చేసింది మధ్యలో సెలవు వచ్చింది. Sir, 22nd వేయండి. Motion is yes, sir.
Your lordship, my appearance for RA document.
RA
Election Commission of India.
Sorry, వర్క్ ఏమో పేరేంటి? రాయండి.
Dippy Hardipur.
కదమ్మా ఉంది ఇందులో.
Yes, your lordship. With respect to ECI, there is no objection, your lordship.
ఉందమ్మా నీ పేరు ఉంది.
DP of pleasure.
Item 91, Muslim and Deputy Governor.
Yes. Anything otherwise? Can I prefer the petitions? Constable the respondents, yes, smart TSHIC. And another petition. Post on that. Yes.
Item 93 CB Raman Reddy, DP for social welfare.
We run the request of the count for the petitions. It's on 21st.
Master of DP for social welfare.
Item 93, item 94, and item 121 are given.
Yes, sir.
Within the review petition before the government was district for this obligation, there is no counterpart in it.
Yes, sir. Verify. Counterpart. Event वाला 21. మన దగ్గర
Our incident content in national number 94 minutes, fishing 413 or 4
ఇచ్చేసేయండి మన దగ్గర ఉన్నది కౌంటర్ మాకు కూడా జిరాక్స్ కాపీలు ఇవ్వండి 21 ఫర్ ఆర్గ్యుమెంట్ sir, what is it? All are connected or different? Start 21st. Start 21st. Constable the petitions. Yes. All three matters. Yes.
Item 121, petition number 464X. Similar in nature.
Item 95 GP for social welfare.
రండి పిటిషన్ నోటీస్ అన్నా చూడండి వెరిఫై చేయండి క్లియర్ గా చనిపోయారు
Two weeks.
Yes, sir.
Item 96 Jitendra Vedmana in authority.
The name of so and so. After 2 weeks. ఏ ఊరు అది yes 12 December. What is the name of our bank?
Gadi Pradesh Kumar.
Yes, sir. Randy, with records of the council petitions to verify the cause and petition surveys are not admitted now for list of petitions. Yes, sir. Yes, sir. With records of the council for the petitions to verify the cause and petition surveys are not. List on 16th December, ma. Yes, sir.
Item 99 TB Chalpatra CC.
Yes, sir. Please. The name of so and so. When do you want list on 23rd? Yes, sir. He said. Kadam Sinvasa.
Item T Ramchandra Rajesh.
What is the name of so and so? Yes.
Item Honorable TSHC Kumar.
Yes, sir. None appear for the petition. Yes, sir.
One not two. T Suvarna Kumari, O 230.
Sir. Yes, sir. None appear for the petition. Yes, sir. What, sir? You are here? Yes, sir. Your name is there? Spell the name of so and so, so and so. None appear for the petition. List on 7th December. Yes, sir.
Item 193, AK Jayapurashu, BG Ravindra Reddy.
Yes, yes, implement so and so, so one pair line. Sir. Coordination does not serve dismiss at the current. In fact, yes, me very good. Yes. Yes, sir.
Item 194, BG Reddy.
Next week,
Yes, sir. I request of David. Request of the council for the petition. List on 7th December. For the respondents. Yes, sir. Nothing survives. Nothing survives. It is written by the council to the respond RV as the survives the current. You know the item? Yes. 105, sir. 105. దీంట్లో 6 వినోద్ గారి పేరు రాయండి. None appear for the petition. Yes.
Item 107, P. Vasunta Reddy. Yes. 106, I needed time this.
Request for the council for the petitions. Yes. What do you want? It's urgent, sir. When is it? When is it? 106, sir. Morning mention is there. Morning mention is there. 2 weeks. Yes. Yes, sir. Yes. 107. Yes. 106 Vasanta Ride. Property petition. Post language to Jodo, sir. I start to do the for the petitions. Comply. Yes.
Item 109, Krishna Kishore K.
Use the same 80 pages having a license center from a bus stand. With the mass insist the rate for the 27 days during the second fund. That the sample court was placed to grant the interim order, page number 28.
Yes, sir. What is it?
28. And on the basis of these orders, these are case also interim orders are granted. That petition is disposed of. Saying that saying that five representation before the
31830.
31830 of 2000.
By the council for the petition of the same subject matter. This petition was disposed of. Petition number 31830 of 2011. Same list petition is accordingly disposed of. Or we have print the name of our record the name of. I don't think this. Yes, sir.
Also stated that
Same
petition stated.
Sir, అదే రాస్తారు సార్ దానికి ఇచ్చేయండి. అదే యాసిడ్ కాపీ ఫిల్ ఇస్తారు కాలం పడకుండా. Yes, sir. Yes, sir. ఆయన పేరు టూమ్ శ్రీనివాసా? Yes, ఆర్టీసీ. పేరు ఎవరు? మయూరెడ్డి దగ్గర. గడ్డం శ్రీనివాస్ అని చెప్పారు. Yes, sir. None appear for the petition. Yes, ma'am. You are for the petitioners?
Item 110, just one lesson, item 1 for the lordship. Answer petitioner, please to time.
Yes, ma'am.
Tax demand for that.
Term direction is there. You are for?
Respondents.
Yes, yes. What is it?
Yeah.
The records of the council for the list on 13th December 2012 matter, sir. And you pending the date. Yes, sir. Sir. Adjustment. Yes, sir. Central power distribution. Yes. None appear for the petition. The request of the council for the petitions. Also list after 2 weeks in the name of Arvind Authority. Date is one.
Item 114, D. Tirupati Road.
Yes, in the name of C.A. University. Also the TSHC. When do you want, sir?
Say whether everything is covered. Only a notice to pay the net charges has been.
Identical matter as well, diesel and some diesel adjustment, I think.
Notice regarding the payment of higher.
Yes, sir. When do you want? It's on 15th December.
Item 5 suspend, item 116.
గట్టిగా పర్లేదు కదా నొక్కమ్మ అది నొక్కది వాళ్ళు చూస్తారు పర్లేదు ఏంటది అది నొక్కమ్మ 116 నొక్కు ఎవరున్నారు 116 నొక్కు పర్లేదు కాదు సార్ నేను కూడా చూసుకుంటా 1 year అయింది కదా ఓకే లెట్స్ వ్యూ ఫర్ అనదర్ వే yes sir
117.
Yes, ma'am.
I have given my vehicle or my and have given to respondent function.
Yes, sir. Clearly covered by the judgment of find out. You have file? File even number choose. What is the name of someone? Tumus was in the place of in-laws Reddy. This term 17th student. Yes, sir. Yes, sir. Your good name? Silence. The petition is passed away long back. Rajamala passed away. Yes. List on 13th December.
Item 119. So people take it.
Yes, ma'am. Anything surprise in this matter? Yes. Find out. As a request of the council for the respondent. DP for tribal welfare. What do you want? Social welfare as a tribal welfare. On 23rd. Yes. Yes. Yes, ma'am.
Reimbursement of scholarship of LTS.
Yes.
No reimbursement amount like that.
Social welfare, yes, sir. Find out the request of GB for social welfare. When do you want? Old matters, 10 years. When do you want? It's on 23rd. అది 117 వేసి ఎప్పుడు ఇచ్చాం మనం వారికి
117 లో ఉంది సార్
ఇది కూడా వేసి ఇద్దరు ఉన్నారు కదా 23rd కేసేయండి రండి పి విజయ్ కుమార్ yes sir
Item 122, a developer with the social.
yes sir For the petitioners. Yes, who is for the respondent, sir? Project Director, social welfare. The counter file. Don't request of the duty first. So tribal welfare. List on 24 for filing counter.
Item 123 and 124.
All are same? Same. Yes.
If I take it, there's a question, people let us capture.
Anvila, Saru. Randy. Really help. List on 22nd. Yes, sir. The end. Your senior not well, huh?
Yes, sir.
23rd. Not arts, yeah?
Post next week, I inform the
Yes, senior, why are you waiting? Because it's there.
Item 127, resolution B, from
It was mentioned 3:30. మీరు చూడలేదా బ్రాకెట్ లో చూడండి 3:30 అని రాసాం చూడండి ఇక్కడ రాసాం కదా ఓ ఈ సాంబశివ ప్రథమం or please come 2:30. ఎన్ని పాస్ అవర్స్ మనకి రెండా అయిపోతాయి ప్లీజ్ ఇన్ఫార్మ్ టు శాలిని గారు ఎస్ yes sir. You need some instructions sir from the corporation. Sir, నేను మీకు దాదాపు ఒక 12 సార్లు వాయిదాలు ఇచ్చాను సార్ ఏ సెట్లా
Orders are extended until
69 reasonable well. Up to 38. Yes, sir. Possible.
Also matter.
Yes, sir. Yes, item 31. No, రాలేదు. Prabhakar, ఉన్నారా?
Yes, madam.
Yes, sir.
Madam, as per the 43.2, 23.2, it is 1 year 2%, madam.
Yes, sir.
If now my petitioner is seeking 2 years extension.
Yes, sir.
Therefore, 2% plus 1%, that is 3%. He has calculated, madam.
Milord, I'm sorry, Milord, I'm C. Raghu, Milord, I'm appearing for in item 31. So, Lordship, I recollect, Milord, yesterday I was arguing based on the regulations. Milord, my friend's junior colleague had furnished a memo. Your Lordship have seen and asked me to look into that memo.
Yes, sir.
The memo, my Lord, should see, Milord, because the regulations I pointed out, Milord, my Lord should see regulations. First, I'll read the regulation, Milord. 23.2.
ఎన్ని ఇచ్చారు కదండి, తీసుకోలేరా?
Sir, they have furnished the regulations, Milord.
Yes, sir.
Milord, regulation 23.2, my Lord should see, Milord. It is titled as penalties.
Yes, sir. Page number?
Milord, page number, Milord, it's a regulation that would be, Milord, page number 22, Milord. Page numbers are at the bottom, Milord should see, Milord.
Yes,
23, it should be.
Yes, sir.
23 at bottom. Milord, penalties where allotments are cancelled for non-execution of the agreement of sale within the stipulated time. Milord, I don't fall within this because my agreement has not been cancelled. Number 1. 23.2. Where allotments are cancelled for non-implementation of the project within 2 years from the date of position of the premises, Milord, that is also not attracted because my agreement has not been cancelled. Allotment has not been cancelled.
Sir, I do not find any regulation in your paper book, sir.
No, I'm sorry, Milord. My parent, yesterday they have furnished the regulations. A copy of the regulation.
తీసుకెళ్ళిపోయారు మళ్ళీ వెనక, అది నాకు ఇవ్వలేదు.
We could not furnish.
That is in the file, I thought. I'm sorry, Milord. I was an impression that that regulation is in the file.
May I request for tomorrow or day after tomorrow?
డబ్బులు లేవా సార్? ఒక్కొక్క కాపీ పట్టుకొస్తారు హైకోర్టుకి. నేను నాకు సీరియస్ అబ్జెక్షన్ చెప్తున్నా సార్, మొత్తం అసోసియేట్ మొత్తం తెలుసుకోవాలి. ఒక కాపీ ఇచ్చి వెనక పట్టపోవడం సార్ కోర్టుకి? డబ్బులు లేవా? ఇండస్ట్రియల్ ఇన్ఫ్రాస్ట్రక్చర్ కార్పొరేషన్.
Sorry, Milord, I could not furnish entire this thing.
ఒకటి తీసుకొచ్చి చదివితే మనం వెనక పట్టుకొని పోవడం. సారీ, ఐఎమ్ నాట్ బ్లేమింగ్ యూ పర్సనలీ. ఐఎమ్ నాట్ బ్లేమింగ్ యూ పర్సనలీ.
Yes, Milord, I understand.
పట్టుకొస్తారు.
We will furnish.
I'm sorry if I hurt you.
No, sir.
Not blaming you personally.
And I understand, Milord, because the entire regulation consists about 50 pages.
దానికి మళ్ళీ ఫైల్ పోయడం, దానికి మళ్ళీ రావడం, ఒక సింగిల్ పేపర్. పోనీ ఐ కెన్ అండర్స్టాండ్. వడాఫోన్ కేసు అనుకుంటే ఇంత బుక్ ఉండదు, కష్టం. చెప్పండి సార్, వడాఫోన్ కేసు అదేమన్నా ఒక సింగిల్ డాక్యుమెంట్, ఒక పేపర్, ఒక ఫోటో కాపీ కేసా? సమతా జడ్జిమెంటా? This day after tomorrow.
Yes, ma'am. Oblige me.
46A Giridhar Rao or Vinod Reddy.
No, sir. Yes, sir. Everybody the why they?
Some 48.
అర్థం కాదు. పరిస్థితి పడేది.
మన దగ్గర డేట్ అడిగితే మీరు
అది పెట్టే మాది. Another for the petition dismissal after tomorrow.
Item 48, D Marine Physical Industries.
Purchase. Council for GP. This is Congress. College if it does not survey, dismissal in purchase.
Item 49, CH Vidyasagar, R Vinod Reddy.
What is the name of Vinod Reddy? John 23.
Item 54 and 55.
Yes, sir. Yes. Please argue.
I will begin or I will not take action on this on the board.
Start password. Yes. Who's offering? Official respondent. Yes, sir.
Item 127. Patricia B.
Yes, ma'am. Yes, ma'am. What is it? Charlie,
Petition I requested the Honorable Court and I will be permitted to read the inquiry process. Here, petition establishes two opportunities provided to the petitioner and before that and permit me place this judgment Canada Bank versus Aspen.
what is the finding?
Canada Bank versus Aspen.
Yes, ma'am. Yes, ma'am.
Page 9 at the bottom of the order with judgment Page 9
Yes,
the order of the order just the judgment based and past third paragraph otherwise I'll read from the page 9 from the beginning regarding the principles of natural justice and the powers of the inquiry authority. In Om Kumar and others versus Union of India, 42. This court observed inter alia as follows. The principle originated in Prussia in the 19th century and has since been adopted in Germany, France, and other European countries. The European countries of justice at Luxembourg and the European Court of Human Rights at Strasbourg have applied the principle by judging the validity of administrative action. But even long before that, Indian Supreme Court has applied the principle of proportionality to legislative action since 1950, as stated in detail below. By proportionality, we mean the question whether while regulating exercise of fundamental rights, the appropriate, least restrictive choice of measure has been made by the legislature or the administrator so as to achieve the object of legislation or the purpose of administrator, as the case may be. Under the principle, the court will see that legislation and the administrative authority maintain a proper balance between the adverse effects which the legislation and administrative order may have on the rights, liberties, and interests of the persons, keeping in mind the purpose which they were intended to serve. The legislation and the administrative authority are, however, given an area of discretion or a range of choice, but as to whether the choice made infringes the rights excessively or not is for the court. That is what meant by proportionality. The development of principle of strict scrutiny or proportionality in administrative law in England is, however, recent. Administrative action was traditionally being tested on Wednesbury grounds, but in the last few years, the administrative action affecting the freedom of expression or liberty has been declared invalid in several cases applying the principle of strict scrutiny. In the case of these freedoms, when exploring principles are no longer applied, the courts in England could not expressly apply proportionality in the absence of convention, but tried to safeguard the rights jealously by treating the said right as basic to the common law. And the courts then applied the strict scrutiny test. My lord, all this is also not relevant in the law. My lord, page 11, my lord.
Yes, ma'am.
I'm reading, my lord, everything appears to be relevant to the issue because, my lord, but it takes much time.
Exactly you want to say by reading this?
My lord, the court, I will also make time for me to read B.C. Chaturvedi onwards, my lord.
Yes. Yes, ma'am.
B.C. Chaturvedi versus Union of India. A review of the legal position would establish that disciplinary authority and on appeal, the appellate authority, being fact-finding authorities, have exclusive power to consider the evidence within a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude and gravity of the misconduct. Here, my lord, admittedly, there is a loss of 53 lakhs to the bank, my lord. It is not that there is no loss to the bank. That we have also stated in the countermeasure. The High Court or tribunal, by exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty. If the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the High Court or tribunal, it would appropriately mold the relief, either directing the disciplinary or appellate authority to consider the penalty imposed or to shorten the litigation. It may itself, in exceptional and rare cases, impose appropriate punishment with cogent reasons in support thereof. In Union of India and another versus G. Ganayutam, this court summed up the position relating to proportionality in paragraphs 31 and 32, which reads as follows. The current position of proportionality in administrative law in England and India can be summarized as follows. To judge the validity of any administrative order or statutory discretion, normally the Wednesbury test is to be applied to find out if the decision was illegal or suffered from procedural improprieties, was one which no sensible decision maker could, on the material before him, within the framework of law, have added. The court would consider whether relevant matters had not been taken into account, or whether irrelevant matters had been taken into account, whether the action was not bona fide. The court would also consider whether the decision was absurd or perverse. The court would not, however, go into the correctness of the choice made by the administrator amongst the various alternatives open to him. Now, could the court substitute its decision to that the administrator? This is the Wednesbury. The court would not interfere with the administrator's decision unless it was illegal or suffered from procedural impropriety or was irrational, in the sense that it was in outrageous defiance of logic or moral standards. The possibility of other tests, including the proportionality, being brought into the English administrative law in future is not ruled out. These are the TCSU principles. As per the Pardeki and Smith, as long as convention is not incorporated in English law, the English court merely exercises secondary judgment to find out if the decision maker could have, on material before him, arrived at a primary judgment in the manner he has done. If the convention is incorporated in England, making available the principle of proportionality, then English courts will render primary judgment on the validity of the administrative action and find out if the restriction is disproportionate or excessive and is not based upon a fair balancing of the fundamental freedoms and the need for restriction thereof. Now, the present case do not fall under any of these irregularities. The position in our country in administrative law, whether no fundamental freedom as aforesaid are involved, in that the court or tribunal will only play a secondary role while primary judgment is where reasonableness will remain with the executive or administrative authority. The secondary judgment of the court is to be based on Wordsworthy and CCSU principles as stated by the Lord Greene and Lord Diplock respectively to find if the executive or administrative authority has reasonably arrived at his decision on the primary authority. Whether in case of administrative or executive action affecting the fundamental freedoms, the court in our country will apply the principle of proportionality and assume a primary rule is left open to be decided in an appropriate case where such action is alleged to offend fundamental freedoms. It will be then necessary to decide whether the court will have primary role only if freedom under Article 1921, etc. are involved and not for Article 14. Finally, we come to the present case. It is not contended before us that fundamental freedom is affected. We need not therefore go into the question of proportionality. There is no contention that punishment imposed is illegal or vitiated by procedural impropriety. As to the irrationality, there is no finding by the tribunal that the decision is one which is no sensible person who weighed the pros and cons could have arrived at loss. Is there a finding based on material that the punishment is outrageous, defiance of logic, neither Wordsworthy nor CCSU just satisfied? We have state to explain. In Chairman and Managing Director, United Commercial Bank and others, PC Keter, the rigid standard to be adopted when considering the case of bank officials were highlighted. Aforesaid being the position, the decision of the learned single judge on the quantum of punishment and the division bench regarding the alleged violation of principles of natural justice cannot be maintained and therefore set aside. The inevitable conclusion is that the odds of dismissal as found to be the appellate bank does not suffer from any impassibility. Appeal is accordingly allowed, but no orders have to cost. My lord, here, my lord, there are no facility. The petitioners are not contending that there are procedural irregularities or ordinance irrational. My lord, only the point they raise is, my lord, ordinance factory, defense factories documents are not provided to. My lord, the inquiry, my lord, clearly establishes that, my lord, we have given ample opportunity to verify the documents physically. Because it is a privilege. In fact, my lord, it is a privileged document to the petitioner as well and to the banker. When during the course of inquiry, my lord, he stated that, my lord, it is a privileged document. He could not enter the premises. Then, my lord, he would have restrained there itself. Because, my lord, the incumbent is dealing with the public money, not his personal money. Therefore, my lord, he was that. In fact, my lord, the scheme and regulations, my lord, clearly provides for, my lord, due diligence in each and every action, especially for bank employees. My lord, 366 onwards, my lord, inquiry proceedings.
Yes, ma'am.
In a way, he is saying that, my lord, principles of natural justice are violated. He is not provided with the due opportunity. Therefore, he could not defend his case. And another crucial important point is, my lord, from the day one, my lord, actually at the end of those cases, my lord, I was the counsel over there. My lord, from the beginning, my lord, when he was fighting for when receiving CRS amounts, my lord, in our counsel, we have clearly stated, my lord, CRS proceedings are challenged before this honorable court, and we are pending that petition, benefits cannot be released. In spite of that, my lord, by filing contempt petition, my lord, and it has went up to appearance stage, my lord. Thereafter, I entered into the record, my lord, and the court has dismissed the counter, my lord, their contempt, my lord, orally expressing that, in fact, the petition is not entitled for single MP during the pendency of the district petition. And not only that, my lord, by receiving the benefits, my lord, at nowhere he has shown his protest under protest subject to the disposal of the petition. He has straightaway taken all the benefits, my lord. Not even a single fine is left with the bank, my lord. All the benefits are received. Now, my lord, the petitioner is estopped from prosecuting. He accepted CRS. He accepted CRS benefits, my lord. Will also kindly permit me to read the inquiry, my lord. Inquiry proceedings speaks, my lord, which establishes, my lord, detailed inquiry was conducted and due opportunity was provided. In this occasion also, my lord, It's not related to this person. Oh, we lost in recovery number 1647 of 2008, my lord, wherein the petition hearing is the respondent over there, my lord. The honorable bench, my lord, clearly observed, my lord, observed that. Just read it out, my lord. This which are irrelevant for the purpose of the inquiry on the charges framed against them. The note appended to regulations so and so, which mandates that employee to show the relevancy of the documents and the witnesses impliedly gives power to the authority to examine the relevancy and to decide whether to allow such documents and witnesses. We are of the view that to examine the relevancy of the witness, there need not be any specific provision in the regulation. Further, it is also well settled in the service jurisprudence that unless employee pleads and proves prejudice caused to him on account of denial of opportunity of examining the particular witness, it is not open to nullify the final order passed in the disciplinary proceedings, which is otherwise in conformity with the regulations. I place this judgment, my lord. My lord, I read from page 66, my lord.
Yes, sir.
This shows, my lord, ample opportunities provided to page 66, my lord, EVO, and read out the state.
This one?
This is
Yes, 66.
as all the documents are filed along with the petition, my lord, along with my counter and I could file it. I have not filed every material, my lord. Page 66, my lord. EVO has read out the statement of allegations and asked it to comment on them and question to CSO whether he is admitting or not. CSO, charge sheeted officer. On receipt of the charge sheet, it was not accompanied by the list of witnesses and list of documents by which articles of charges are prepared to be proved. In continuation with the reading of the background of history of the case by CSO, it is decided whether the subject matter only, but not full history. CSO, I have not read out any history or background. I have only tried to submit the substantially of my requirements of for defense. I also place it on record and that I protest EO's approach of getting belittled of recording my submissions as dictation. EO requested to a CSO to give the reply to the allegations only. CSO, in absence of verification of fines, documents and vouchers at the branch of Sangareddy, I will not be in a position to admit or deny the allegation of charges. Therefore, I request you to arrange for a copy of letter written by ODF authorities to branch of Sangareddy as detailed in my representation dated 11/4/2006. A copy of the same submitted to you now. Regional Manager statement report P.S. Narayanagowda on the subject. Requested to allow me some time for collection of documents, etc. for the submission. Inquiry proceedings adjourned and next date of inquiry will be invited in due course of time. The last meeting on 4/5/2006, PO was asked to take up the request of CSO with DA with regard to one allowing CSO to branch Sangareddy for verification of documents, for a copy of letter by ODF authorities and RM statement for before PS Narayan. Try to procure the copy of the letter of PO. Try to procure the copy of letter of ODF authorities and produce the same in next sitting. PO has been directed to post the copy of ODF letter to CSO and information to EO to avoid delay. PO, it has been reported that RM's statement before PS Narayanagowda is a privileged document and cannot be provided by DA. In respect of according permission to CSO for verification of files, etc., and branch of Sangareddy, the DA stated the EO is competent authority to decide. CSO is allowed to visit the branch of Sangareddy for verification of documents, vouchers, etc. for 1 day. In case of any difficulty in providing documents, etc., it will be considered on merits. Opportunities given. CSO, notwithstanding the verification of files, vouchers at one branch of Sangareddy, CSO wanted the PO to proceed with presentation of his case further. He himself waived here, my lord. He himself waived. Opportunity is provided to verify, and he himself waived. PO has submitted following documents in respect of an account of Srimati J. Aruna. All these documents are provided, madam, up to 3. PO had provided all the documents. PO, as the documents to be mapped are not in proper order, hence PO has been asked to arrange the same in proper order and represent in the next sitting for making as exhibits. Inquiry proceedings adjourned to next proceedings. Next proceedings date will be implemented through post. 69. In continuation of last sitting dated 13/6/2006, making of management exhibits of loan of Srimati J. Aruna is continuing, and all these exhibits are provided. This is up to my lord, page 72. And management, my lord, page 72, my lord, management exhibits from serial number 26 to 47 are Xerox copies signed by PO. CSO, objection production of Xerox copies without attestation from the originals, and the exhibit do not contain full set of AO forms inclusive of identity cards produced by the respective account holder in respect of M exhibit 26 to 47. PO answered it, my lord. Management exhibits 26 to 47 are Xerox copies taken from Xerox copies available in branch of Sangareddy. That it is reported by Sangareddy that the originals of said exhibits are taken over by the CBI authority. This may be noted, my lord. These are taken by the CBI authority. The PO has addressed that one also, my lord, where he has taken objection that Xerox copies are made as exhibits. CSO, from exhibit management exhibit 26 to 47, it is observed that AOFs are missing in certain cases, SS cards are missing in certain cases, and reserve portions are reverse portion of the identity cards only appear in certain cases. Therefore, I request you to direct PO to produce missing portion in the above said exhibit, since the branch must have taken acknowledgement by handing over the same to any investigation authorities. This was also answered. Complied, in fact. PO is advised to obtain the missing documents as stated by CSO from management exhibits 26 to management exhibits 47 for further marking. PO is asked about the position of the ODF letter as requested by CSO during last sitting dated 13/6/2006. This is important, my lord. PO is not, it is very much vigilant and very fairly it is conducted. PO stated that he has filed for ODF letter from regional office and got a letter dated 25/7/2006 from K. Vijaydan for General Manager ODF stating that the matter has been referred to CBI. A receipt of clearance for CBI same would be forwarded. PO. Ask PO whether production management exhibits completed. PO. Remaining documents, if any, will be produced on or before 5/8/2006. PO. Ask PO whether you are producing any witness from management side. PO. I will produce witnesses, if any, on the next sitting and shall proceed with the presentation of the case. Inquiry proceedings adjourned to 9/8/2006. PO. Page 74. I have some more documents to produce as management exhibits. Management exhibit 50, a copy of letter of acknowledgement of Inspector of Police dated 12/6/2006 for taking over certain bank documents from branch of Sangareddy. Exhibit management exhibit 51, a copy of the standard pay scales of central government employees, 5th pay commission. PO. I may be given permission to introduce JC Pradhan as NW1. EO permission granted. EO there. NW1 with regard to the period of visit to Sangareddy and the outcome of the visit. MW1, I got a written instruction from Chief Vigilance Officer of our bank to investigate into irregularities in disbursement of MW1, I got written instructions from Chief Vigilance Officer of our bank to investigate into the irregularities in disbursement of loans at branch of Sangareddy disbursed by Mr. Petitioner LSR. I have visited branch of Sangareddy during the first week of July 2005 for investigation and submitting of loan accounts. In the course, I have visited the addresses of all the borrowers mentioned in the charge sheet of LSR notice available in the loan application forms and found that the said borrowers were not staying at the address given. Instead, some of the employees of ODF were staying in the address since 10 years. And this is crucial. I went to J. Arna's quarter and found it was lawful. During the interaction with the neighbors, it was reported that she was arrested by the police and after that she is not seen. I took help of Mr. Chandra, the staff of branch of Sangareddy for visiting all the above addresses. During the interaction with some of the employees of ODF, it was reported that above said borrowers were not employees of the ODF. PO did not meet ODF authority. An earlier para is crucial. Did you meet ODF authority? MW1, during that visit, I did not meet any authorities of ODF as it was prohibited area and I was in hurry to submit my report. I could not meet the said authorities. But let us say she met. PO, after that, did you meet ODF authorities? MW1, during July 2006, I had been to ODF with a list of borrowers. A copy of the same was handed over to ODF authorities with a request to verify the genuineness of the borrowers, whether they are employees of ODF or not. I went to ODF to meet Mr. MS Rao, Joint General Manager. My lord, you lords may kindly appreciate, my lord, all the efforts are made, my lord. Joint General Manager, ODF, as he was engaged otherwise, I could not meet Mr. Chari, Vigilance Officer. He told that they are in receipt of our bank's request letter. And the photo ID cards are to be verified by the scrutiny department, so they would be giving reply after 4 days. After having confirmation over telephone, I went to ODF and met Mr. Sharma, Vigilance Department ODF, as Mr. Chani was not available. And I was told that as the similar information to CBI at their request and as the matter is under CBI investigation, it would not be fair on their part to pass the same information to us without clearance from CBI and asked us to wait some time for their reply. Again on 7/8/2006, I have contacted Mr. Sharma ODF with regard to their reply and I was told that still they are waiting for clearance from CBI. EO, my chief examination completed. EO asked CSO to proceed with cross-examination. For all these reasons, I placed this judgment.
Madam, your entire case is, I am not sitting in appeal authority. It is only judicial review. Kindly let us confine to the extent your officer yourself saying that these certain documents were not provided to Mr. Murthy.
Yes.
That is the only point for the consideration, madam. After that appeal review, in this review, your officer himself recorded saying that Mr. Murthy was not given what the opportunity to access to the certain documents which were not provided to Mr.
Stated by the CSO that my lord, he could not verify the documents because it is a privileged area and privileged document, my lord. Then how come the documents and they are not the employees of the ODF, my lord? Here, malafits are not established, my lord, and not only that.
It is not my, madam, it is not my finding. It is a finding of your chairman, managing director, review authority.
My lord, the review, my lord, on military grounds, my lord, it is modified the punishment from dismissal to the compulsory retirement. That is, that is.
Having regarding the statement certain that that it's true that certain documents were not provided to Srimurthy, you have shown the sympathy.
My lord, yes, because my lord, my lord, there is same charge sheeted officer, petitioner was also allowed. My lord, it is a case of just loss, my lord, there is a loss to the bank. My lord, a bank employee, my lord, the irrespective of all.
There is no charge that the loss is passed to the bank.
My lord, in the due course, it is. My lord,
I'm saying something across the bar.
my counter has stated.
What means of saying it in the counter?
No loss.
My
There is
lord,
no loss to the bank. There is no loss to the bank.
my lord, in my counter, I have
Don't
stated.
make allegations across the bar.
My lord, I have
Then there is a same point.
my counter, my lord.
What do you point it reading from the counter? This will video before the court.
My lord, counter
First of all, must get the charge.
is filed by the employee of the bank, my lord, clearly stating that there is a loss. My lord, my humble submission is, my lord, that an incumbent is not vigilant in sanctioning the loans, my lord, who are not the employees of the ODF factory, my lord. Those persons were given sanctioned loans of huge amounts, my lord.
In that case, why the finding was given by your chairman, Marinda Reviewing Authority, saying that certain documents are not provided to Mr. Murthy?
That, my lord, out of the proceedings, my lord, it is not fair to submit, my lord, what had taken place at that stage.
సరిపోతుంది కదా ఇంకేం కావాలి వాట్ మోర్ యూ
Placing that here, my lord, because, my lord, there is the inquiry report clearly states, my lord.
after that appeal revision review your review authority chairman mandated review authority saying that not documents are not provided to Mr. Murthy.
Punishing authorities or punishing authorities order was confirmed by the appellate authority. On humanitarian grounds, my lord, and dismissal order will preclude him from securing employment in elsewhere, my lord. Punishment was modified. Generally, my lord, reviewing authority will work on humanitarian grounds. That's the reason why it is modified. My lord, is it not relevant here, my lord? The president is the by filing various writ petitions and contempt applications, my lord, amounts were received without protest, my lord. Without protest, he has received. Is he entitled to proceed with this writ petition, my lord? Is he not stopped, my lord? Humble question, my lord, to myself, my lord. Having received all the benefits at this length of time, my lord, I place another judgment, my lord, wherein the Honorable Supreme Court clearly stated that, my lord, after the length of the time, my lord, if the orders are reversed, my lord, all the settled accounts cannot be reversed by the management. My lord, your lordship kindly permit me to read this inquiry report, my lord, because he himself also admitted that it is a privileged document, it is a privileged area, he could not enter there. Then what compelled him to sanction the loans, my lord? The very same question is being posed by the bank to the council, my lord. What compelled him?
You have to ask the same query to your mandator chairman.
Very same bank employee, my lord. In fact, my lord, if he is dealing with the public money, my lord, he has to be very vigilant, my lord. Apparently, there is an error, my lord. Because without going into the payslips. My lord, CBI case is also lodged. My lord, CBI case is well. In such case, my lord, pending this litigation, he received all the benefits. Pending litigation, CBI case, my lord, let this be pending, my lord. After the disposal of the CBI case, my lord, this will be decided. Because, my lord, the CBI case, my lord, in the CBI case, there is acquittal conviction, my lord. And there is a, I understand, my lord.
What is the bearing of the effect of the criminal matters into department inquiry?
Originals are with the CBI, as stated earlier. My lord, your lordship, kindly permit me to read this inquiry report, my lord. This will establish, my lord, how detailed inquiry was conducted, my lord. Even the judgment, my lord, clearly states, my lord, that clearly states it's not the.
Are you really subscribed seriously about the judgment is applicable to the present case? Are you really sure? I'm not object. Are you really sure? The judgment is applicable to the present case?
I'm
Yes,
looking
ma'am.
to apply.
Yes, yes. చెప్పండి రండి నోట్స్ రాసుకుందాం పట్టవా చెప్దా చెప్పండి నోట్స్ రాసి ఇచ్చారా ఎస్ సార్ వన్ సెకండ్
I will also file my written arguments.
ఓకే ఏది తీసుకోవాలి ఫస్ట్
19516.
ఇదేనా
19516. The issue is one and the same in both, Mano. The tender works different. Parties are also same. 19516.
ఇదేనా
Yes.
నోటిఫికేషన్ ఏమి ఇచ్చారు
The tender notification can be found at page number 20.
50
Page number 20. 20. So this is concerning preventive periodic maintenance works on mills of unit 4. So there are 4 units in Bhadraji Thermal Power Station.
One second. Which one kindly read?
Page number 20.
20 yes.
Is a tender notification. The subject can be seen preventive or periodic maintenance works on mills of unit number 4 for the financial year 2023-24. Just for some background, Mano, there are 4 units in Bhadraji Thermal Power Station. Each unit has 2 works.
You have stated in
majority works, mills and feeders.
You have stated in affidavit?
Yes, I have stated.
Yes, sir. Yes, 4.
In this particular repetition, we are concerned only with one work in one unit, Mano, that is bowl mills of unit 4.
4 works.
4 units, 8 works.
Yes, 4 units.
Each unit 2 works, that way 8 works in total.
8 works.
The first repetition is.
You are confined to the extent of unit?
The first repetition, unit 4 bowl mills. It can be called unit 4 mills.
Unit 4 mills, yes, sir.
Second repetition, Mano, is regarding units 1 and 2, both mills and feeders. So that is 4 works.
1 and 4,
1 and 2 Mano. Second repetition.
Mills and 4 works.
Unit 1 and 2, mills and feeders. So 4 works.
Better we have confined only first issues.
Just for some background.
Confusion.
నేనేమి కన్ఫ్యూజ్ కానీ అవసరం 12 దాకా మనం ఇక్కడ విన్నాం నేను షాదాపులో నీకు బిర్యానీ కూడా చెప్తాను కంగారు పడకు చెప్పండి
Confining only first repetition. Page number 30 may be seen.
Page number 30.
30.
Yes, sir.
Special terms and conditions. Clause number 2, documents to be submitted. Subclause number 2, other documents is relevant.
Yes, sir.
Here it says, copies of previous work orders for similar works or certificate showing minimum 3 years experience in TS Genco in similar type of works on any one of ball mills, comma, self-declaration of relevant technical skills, etc. To substantiate this, my lord, your lordship posed perfect question yesterday, my lord. Is there any preferential treatment in favor of the 6th respondent, or the terms of the tender conditions are applied equally to all the tender bidders? I'm saying they were not. The reason is because every other tenderer, including the petitioner, have submitted work experience in their name, whatever work they have previously performed. But the 6th respondent is special. What happened with the 6th respondent is, my lord, page number 10 may be seen, my affidavit. Page number 11.
Occupation Chief Engineer BTPSR.
Yes, ma'am.
7th respondent.
7th respondent, I made him in a personal capacity also because I made personal allegation. That is why I made him as a personal respondent, but I'm concerned with the 6th respondent.
Srinivasara, okay.
Yes.
Yes, sir.
Now, kindly page number 11 may be seen. Para 7. Page number 11, para 7 of some have tabulated the documents submitted.
Yes, sir.
These are the documents submitted, my lord, by the 6th respondent to substantiate that clause regarding work experience. What is so special about the 6th respondent is that the bid is submitted by his sole proprietorship called Mars Engineers and Enterprises. But the work experience document submitted
Mars Engineers and Erectors.
It's a different partnership firm which had been defunct for the past 7-8 years now. No history of Mars Engineers and Erectors in this kind of works. All of a sudden he comes up with these documents. And secondly, my lord, kindly the page may be turned, page number 13 may be seen. Page number 1, they have all of these documents. I will show the documents, but just for the comfort of you are just tabulated them.
Yes, page number?
Page number 13, para number 11 may be seen. The tender document, my lord, in the same clause, the clause which I have showed.
Page 13?
Page 13, yes, page 13, para 11. The tender notification also requires these statutory documents to be submitted like GST registration, EPF, ESIC, Udyam MSME,
The documents submitted by the sixth respondent, sole proprietorship, Mars Engineers and Enterprises are tabulated there, not in para number 11. The date of registration for everything is October 2022. It has no commercial history for it to have any work experience. It was registered only in the month of October last year. There can be no possibility of Mars Engineers.
There are two issues. One is the erectors as well as the second one is this come.
This dichotomy.
Enterprise and erectors, main objection. So Rusty is concerned income certificates.
The income certificates also I have showed only to substantiate. The tender notification requires income tax returns to be submitted, and page number 71 and page number 77 are the income tax returns.
Yes, sir.
In which there is no whisper of income concerning this kind of works. Only some real estate proceeds, some rental income. Nothing related to this kind of work. For the past 2 years, they have submitted income tax returns.
Yes, sir.
And you know that the surprising aspect right now is that a firm that was absolutely unknown in BTPS in the past now holds all the contracts. I have a list of contracts that have been awarded because the lordships have posed this question in the previous hearing, which is why I went back and inquired with the party member. And I'm finding them in my written arguments. I have them ready to read out as well here. Unit 2 of burners servicing, Unit 1 rollers, Unit 2 rollers, Unit 3 burners. All the contracts have been singly and solely granted only to the sixth respondent. This is clinching proof, but there is only one last proof I'll show of the pollution, which is incontrovertible. That final proof is that I will show the documents that on 3/6/2023, the petitioner on 3/6/2023, at page number 63 is the representation of the petitioner to the respondent authorities on page number 63.
Yes, sir.
Explaining these kind of illegalities that are occurring in BTPS and communicating his grievance. This letter was received on the same day. That can be seen at the endorsement in the bottom left corner of the same page, 63 page.
Yes, sir.
Having received that on 3/6/2023, page number 101 may be seen. Page number 101 and 106, my lord, are proceedings cancelling of the same day, 3/6/2023, cancelling the other works I had in the BTPs.
What is this, sir?
On the same day.
I will explain.
Kindly page number 101.
What of his letter only? His letter, she correctly said that can cancel. Then only we have cancelled. No, I explain my counter. I explained my counter. You have not issued my counter like this.
Yes, 101 and
101. Unnumbered second paragraph. This is from superintending engineer to the petitioner. On the same day, 3/6/2023, two of the only contracts which the petitioner previously had were cancelled. The unnumbered second paragraph says, in this connection, it is regret to inform that the e-tenders invited by reference was cited above are hereby cancelled on administrative grounds. No further correspondence will be entertained in the matter. I have attached the work order issued in our favor also at page number 99. 99 is the work order, 101 is the cancellation on 3/6/2020. Same is the case with Unit 1 feeders. In both Unit 1 mills and feeders, this is what they did. Page number 106 is Unit 1 feeders. So these are the state of affairs there.
పాపం మీరు విజిల్ బ్లోయర్ గా ఉండాలనుకుంటే మీకు విజిలే మిగిల్చారు వాళ్ళు ముందుకోమని.
May I say one thing? It is not an issue only pertaining to me, and my grievance is not that I did not get selected. That is not at all my grievance, my lord. I have many other works. The issue is every other tenderer is worried and troubled by this pollution, but it is only the petitioner who is able to approach this honorable court, my lord, because your lordship knows with your breadth of experience the harassment that the unsuccessful petitioner would face at the hands of the respondents, which is when only the first petitioner could come to this honorable court. Every other tenderer is highly troubled because all the tenders have been granted, my lord, in this fashion. Some of the tenders previously granted to others in the same way as I suffered were cancelled and granted to sixth respondent. Tens of different workmen are out of job site. It is only the sixth respondent who colluded with the fifth respondent. When I submitted representation, my two contracts are also withdrawn without any reason on administrative grounds, and no further communication will be entertained in that regard. But these are the conspicuous of facts I would like to present before you. Lord, before the jurisdiction of this court, I'm not before a civil court for adjudication of a contract dispute. I have to show this pollution and injustice. These facts and conspicuous in aggregate, I have to present. This is my limited subject.
Yes, sir.
I will find my written arguments under the note. I reserve my right to submit shorter arguments.
What is the cost of this work?
Only 10 lakhs. 10 lakhs.
Only 10 lakhs.
10 lakhs only, Malak. This is why this issue is with regard to not just the petitioner, Malak. Every tender who are executing small works, they are all being wiped out from BTPS, and a monopoly is sought to be created right now in the hands of the fifth and sixth respondent. That is the larger issue at stake, Malak. For that matter, the second petition has 4 contracts, Malak, each of 10 lakhs. This way, all the tens of different contracts are being handled and hand given only to the sixth respondent. By hook or by crook, by manipulating the process. And remember, there is only one last thing I would say, because they will accuse me of other things again. But I filed this corrigendum at page number.
There are your brothers.
Absolutely, I admire my elder brother. Right outside the court, I look up to him and I take his advice in everything. Page number 60 is the corrigendum. When they realized,
which one?
Is page number 60. Can you page number 60 maybe? When they realized that the sixth respondent won't be in a position to submit work experience in the past for 3 years, they suddenly issued this corrigendum. At page number 62 can be found the amended clause. Page number 62 is the amended special terms and conditions. Same clause I would like to read. Clause 2, subclause 2, other documents, subclause 1. Copies of previous work orders for similar works or certificates showing experience in similar type of work on any of XRP ball mills in TS Genco, self-declaration of relevant technical skills, etc. The 3 years requirement is removed altogether.
I think Marangu eligible.
Anybody is eligible.
But in case
Reference to words like limited tender, self-declaration is nothing but an admission of arbitration in the tender process. These are my limits.
Avan, ఒక నిమిషం ఇది మార్చి అరే నేను ఇక్కడే పోతా
for 2023 for work of preventive protection maintenance for midst of the financial year. But not for the EPC work in unit 4 for BTPS as a business petition. Please see the petition mirror, paragraph 4 of the petition.
Let us.
The overlap one that
back.
Not for EPC work in unit 4 as manageable. It is true the tender has only single part. And does not have any pre-qualification or technical evaluation stage. And moreover, thereafter,
Yes, sir.
Paragraph 7 of my counter.
Yes, sir.
I submit that in reply to paragraph 11 to 12 of the spirit, income tax clearance certificate is required either from the firm or individual.
Paragraph number 7.
7 of my counter.
19516, page number 5, paragraph number 7.
It was counter. My counter. 5 2 to 5.
Counter file, sir. Respond number 6. Sorry, sir. 2 to 5, kada?
Yes.
Yes. Yes, paragraph number 3, 4 and 7.
Yes, paragraph 3, 6 meters of participated in that, and only one has become only one. And paragraph number 7.
Yes.
The income tax clearance certificate is required either from the firm or individual on our contractor. In this present case, respondent number 6 has submitted income tax return for financial year 22-23. Commercial history of tender is not criteria for financial history. Because commercial history only last year I would like to give you an illustration. If I go to a hotel, they will ask me PAN number or the number. They can't do anything with that PAN number. Only for the purpose of security purpose, securitization purpose, security purpose only. Because if anything happens, well,
So the nature of this work?
Only to
periodic and preventive maintenance works. Maintenance work. Any problems with the machinery, repairs of the machinery.
Compared to this
The technical.
not required.
At least
old maintenance.
I said grease plus oil, but
That's what I don't know.
what to say? Respond number 6 meeting. What is the nature of this work?
Nature of this to maintain the whole mills.
Only this
technical experience is not required.
But people
what the maintenance also says that experience is not required.
Horizontal, page number 60. Look, this horizontal issue already explained in my thing.
Yes, read it.
Yes. Page number 8. Paragraph 8. My counter.
Yes, sir. Yes, please.
Submit in reply to paragraph 10. As per TSHC standard general terms and conditions, the tenderer should have experience in executing a similar type of work.
Yes.
At least once in the last last financial years, including present financial year. In this regard, it is submitted that Horizontal 1/5/2023 was issued to the original NIT 18/4/2023 e-tender of 28/4/2020, wherein similar experience, any type of bore mills were informed to be considered.
How can you say that Corjam has issued in the interest of the organization?
No, it's because of that. In fact, Horizontal was issued next time.
Yes.
In fact, Horizontal was issued in the interest of organization. It is submitted that on 18/4/22, it was published on e-platform, and Horizontal was published on Monday itself. Friday it was 28/4/2023. The Friday.
Interest of the
expand the scope of the invitees. Tender new invitees. Because of that, only 66 tenders are participated. Even in this, I will finish. In this also, if it is 3 years experience as stated in previous before Horizontal, even the petition also is not in. Just let me. I have explained it. Why? Yes. Petition is also not explained. I'm not eligible. Not in that. Paragraph 4 is clearly stated.
Yes, sir. Your counter?
Yes, sir. Next page of the paragraph.
Yes, sir.
Further, it is submitted that next page,
Which one?
next page of the top. Paragraph 4 continuation. Further, it is submitted that
Clause 2.
Yes, clause 2 of section 2, that is special tender condition in NIT, which was issued in e-procurement platform at tenders mentioned. And the same was amended well. In the same tender notification and in the novel, it is not stipulated to.
It shall be dismissed in limine. Yes, yes.
Yes, sir.
Another it. Yes, sir. Yes, sir.
Further, it's submitted.
Okay, I got the point. He himself is dismissed in limine. He has no locus. If that is a strict implementation of that rule, he is also out of the track. Yes.
That's why the provision was here given, and six tenders was participated, out of which one has been involved.
That's all.
And moreover, I would like to lay upon judgments. I mean, judgments passed by the Honorable Supreme Court as well as Delhi High Court.
This court doesn't have any power or authority to look into the contract unless last illegality was established by this one. It is pairingly.
Yes,
Celia and Paridwara, yes, sir.
Motor, the Tata Motors. Yes, sir.
Yes.
Show me
the paragraph.
Paragraph 52, 53, and 55. 54 and 55 of Tata Motors. Last judge, 1 second.
At 54 also BC.
Yes, 54 also. Paragraph 52.
Yes, sir. Yes, sir.
Ordinarily, a court could not refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of tender unless something very gross or culpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at not the entire tender process at the stage when the contract is well underway would not be
indicating a question process stage at the consumer a lot of time and as well as the
This is evident from the three benches. It was passed on by
to the tune of crores of rupees. 10 lakhs.
53.
Sir.
The law relating to award of contract by state and public sector corporation was revived in area of and it was held that the award of a contract, whether by a private party or by a state is essentially a commercial transaction. It can choose its own method to arrive at decision, and it is free to grant any relaxation for bona fide reasons if the tender conditions permit such relaxation. It was further held that the state and its corporation, instrumentalities, and agencies have public duty to pay to all concerned, even when
public interest not vary on the ground of the legal point.
Now, my last friend has furnished so many judgments only with regard to public interest education and the public exchequer.
A judgment applicable ka
Yes, sir.
Paragraph 54 also very
ఇక్కడ ఎంజాయ్ చేయట్లేదు ఆ ప్రొఫెషన్ అసలు మొన్న ఇది మొన్న వచ్చాడు ఆ జడ్జిమెంట్ చూడలేదు నాకు ఇంకెవరే లేదు ఏదో జడ్జిమెంట్ ఇస్తే ఆ జడ్జిమెంట్ దీనికి అప్లికబుల్ కాదంటాడు మీరు చూసారంటే చూడలేదు
examining the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Court should even be more reluctant in interfering with the contracts involving technical issues as there is a requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should not find fault with the magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is out compliant with the procedure contemplated by the tender process, tender conditions. If the court finds that there is a total arbitrariness or that the tender has been granted in a manifest manner, still the court should refrain from interfering in the grant of the tender, but instead relegate the parties to seek the damages for the wrongful exclusion rather than to inject the execution of the contract. The injunction or interference in the tender leads to additional costs on the state and is also against public interest. Therefore, the state and its citizens suffered firstly by paying escalation costs and secondly by being deprived of infrastructure for which the present day governments are expected to work. This is what honorable makers say.
చూసారుగా ముందర కాలకు బంధం వేస్తారు వాళ్ళిద్దరు కలిసి. వాళ్ళిద్దరు చూసారా ట్విన్స్ లాగా కవల పిల్లలాగా ఉంది సార్ కలిసి.
As far as the president is concerned, your lordship has described without looking at the judgment. For instance, I find compilation of judgments, Lord. The objective of filing that is just to show before this court that there is enough latitude provided by the Honorable Supreme Court that where there is public interest involved and some arbitrariness is proved, this ongoing post intervention is completely justified. But without even referring to that particular judgment, I will just read out one paragraph from the Honorable Supreme Court judgment. I filed 564, only one paragraph I will read. For instance, in the compilation of judgments, I filed the first one. Page number 14, paragraph 37.
Synopsis, sir?
No, my compilation of judgments are filed. I will just read out that one paragraph just to show that there is enough freedom of
Yes, sir.
Paragraph 37 says a large number of.
Which one, sir?
Paragraph 37. My compilation of citation, memo of citation.
Judgment
on 27/9/2023. I filed. First judgment, my lord, on paragraph
11/9/2023.
2009 6 SEC 171 citation. Memo of citations are filed. That may not be the one. Must have been filed by the respondents.
Those for the petitioners.
I think that should be. Kindly, paragraph number 4, page number 14, maybe.
Page number 14.
1/4.
Yes, sir.
There is a compilation of filed.
చూడండి
Memo of citations.
రెండు ఉన్నాయి కదా.
Not party. Development authority.
This one?
Yes, that's the one.
Yes, sir. Yes, sir.
First judgment. As 37, 38, 39 are relevant. I've put the relevant paras also in the table in the start. I've read out only one. 37 paras. A large number of authorities have been cited before us in support of the submission that even in contractual matters, the state or other authorities are bound to act within the legal limits and their actions are required to be free from arbitrariness and favoritism. The proposition that decision, even in a matter of awarding or refusing a contract, must be arrived at after taking into account all relevant considerations, eschewing all irrelevant considerations, cannot for a moment be doubted. The powers of the state and other authorities are essentially different from those of private persons. The action or the procedure adopted by the authorities which can be held to be state within the meaning of Article 12 while awarding contracts in respect of properties belonging to the state can be judged and tested in light of Article 14. Once the state decides to grant any right or privilege to others, then there is no escape from the rigor of Article 14. These principles are settled by judgments of this court in so and so judgment. And para numbers 38 and 39 also reiterate the same reasoning. In fact, even in the Tata Motors judgment, also in para number 54, the judgment that is cited, para number 54, for instance, it says, if the decision relating to award of a contract is bona fide and is in public interest, court will not interfere by exercising powers of judicial right. Therefore,
para number 54, same judgment.
Tata Motors judgment is same item, and they read one. I'm just offering one sentence out of it.
One second. See.
Para 54.
Yes, sir.
Para 54 in that judgment, that is on the last page. It says, as observed by this court, para 54, page 90.
Yes.
As observed by this court in Jagdish Mandal versus State of Orissa report and so and so, that while invoking power of judicial review in matters such as tenders or award of contracts, certain special features should be borne in mind that evaluations of tenders and awarding of contracts are essentially commercial functions, and principles of equity and natural justice state a distance in such matters. I'm not really natural justice or equity. If the decision relating to the award of contract is bona fide, and that is italicized by the Honorable Supreme, and is judicial and is in public interest, courts will not interfere by exercising powers under judicial review, even if procedural aberration or error in assessment of prejudice is possible and is made out. Therefore, the italicized word of bona fide and non-arbitrariness are not sine qua non. They cannot be eschewed. They have to be there, and that cannot be controverted by anybody. They settled law. And I have filed multiple other judgments to that effect, just to show, my lord, that this honorable court's imminent and considered intervention is absolutely necessary in these facts.
లైన్లు మిస్ అయ్యారు కొంచెం రెండో లైన్ కూడా చదవండి.
In that same panel.
పవన్ రెడ్డి అదే ప్యానల్ అక్కడతో ఆగిపోయారు ఇంకోటి చదవండి. పవన్ రెడ్డికి శర్వానందంగా ఉండదు. ఎస్ చదవండి. ఎస్ అదే అదే జడ్జిమెంట్ చదవండి అందులో
judicial review will not be invoked to protect private interest at the cost of public interest or to decide contractual disputes.
మొత్తం కలపకూడదు. కామాలు వచ్చి గారు పవన్ రెడ్డికి అర్థమైంది. ఎస్
This is exactly my argument.
మరి అది ఎట్లా వదిలిపెడతారు?
I am not political, but that is exactly my argument. I am not doing this for my sake. I have other contracts, multiple other contracts. I am not doing this for my sake. This writ petition, my lord, is filed only by one tenderer who is dare enough to approach this honorable court. Multiple other tenderers are aggrieved by the number of tenders that were granted in favor of the sixth respondent. It is only me who could come forward. I have no interest in only being the sole successful tenderer. That is not my intention.
I mentioned, if the horizontal is not published, even petition also is
I have attached
these are that bona fide nature. Bona fide activities. No signal. Those are also the petition of last 3 years only. I have explained, 3 years is 21, 22, 23. 2 years only. 2 years experience only.
Kindly read page number 144, para number 23, last line. నీదే పవన్ జడ్జిమెంట్ ఉంది కదా, పవన్ మీరు ఇచ్చిన జడ్జిమెంట్ లో 144 para number 23 ఉంది కదా, మీరు ఇచ్చింది సినాప్సిస్ తో పాటు ఇచ్చారు కదా పవన్, మీరు ఇచ్చిందే 248 లో దాంట్లో లాస్ట్ పేజ్ నెంబర్ 23 పేజ్ నెంబర్ 144 23 లాస్ట్ టైం చదవండి. లాస్ట్ 2 లైన్లు చదవండి.
Court should refrain from interfering in the grant of tender, but instead regulate the parties to seek damages for the wrongful exclusion rather than injure the execution of the contract. The injection or interference in the tender leads an additional cost on the state and is also against public interest.
Yes, sir.
Already work has been like 80% of work has finished. No,
may I submit one? Not some proper in saying in the very first hearing, single judge was highly convinced to pass interim order. The only reason for not doing that is because I approached this honorable court after a delay of 3 weeks because I had some trust in the respondents. Page number in the last paragraph of my
Check the respondents, sir.
On the respondent, because I have been addressing numerous letters to the respondents and I have been visiting their offices. In the last paragraph of my letter, para number 18th paragraph, I have tabulated my efforts in having the matter redressed in the stage of respondent's office itself, which is why there was a slight delay in approaching the honorable court, which was the only ground for not passing interim orders and posting the matter for counter with only 1 week's time. Single judge previously cognizant of the matter had granted only 1 week time.
Counterfeit within 1 week?
It was for the time was taken after the Gulf roster change in the matter was taken. But in any case, the matter was viewed very seriously at the interim stage itself. It is my innocence that I trusted the respondents. I approached this honorable court with a deal.
And another judgment, quietly act is the second petition.
Which one, sir?
First Delhi High Court.
Just now read.
Bharat Power Control System. This first one.
You have filed 3 judgments, sir?
Yes, sir.
3, yeah?
Yes, 3.
Yes, sir.
First one, it is very after the second petition.
Yes, sir.
The Bharat Power Control. Laid upon paragraph 20 21, 23, and 24.
20,
20, 21, 23, and 24.
yes, sir.
21. It is clear from the above, the state, the Supreme Court had held that before the page number 20, paragraph 20 minutes. Paragraph 20, this contention of the respondent is squarely covered against the respondent by the decision of the Supreme Court in New Horizon Limited case, Supra, paragraph 23, because it was extracted by the
Yes, sir.
Paragraph 23. Even if it is assumed that the requirement regarding experience as set out in the advertisement dated 22/4/1993, inviting tenders is a condition about
One second, Power. Where is it? Synopsis, yes, Manapatra.
20.
In the page number 42.
No. Synopsis not.
No, inner page is not the para.
Paragraph 20.
Yes.
Is third page. Third page. Last sentence are
Correction response clearly covered. This one?
Yes. Yes, clearly covered.
Yes,
Please extracted. Paragraph 20 of the 23 of the New Horizon judgment are extracted in this. Paragraph 23. Though it is not paragraph 23 in this judgment, but 23 of the New Horizon.
Okay.
Even if it be assumed that the requirement regarding experience as to set out in the advertisement dated 22/4/1993 inviting tenders is a condition about eligibility for consideration of the tender. Though we find no basis for the same, the said requirement regarding experience cannot be construed to mean that the said experience should be of the tenderer his name only, in his name only. It is impossible to visualize. It is possible to visualize a situation where a person having past experience has entered into a partnership and the tender has been submitted in the name of the partnership firm, which may not have any past experience in its own name. That does not mean that the earlier experience of one of the partners of the firm cannot be taken into consideration. This is what, as per the judgment based on the as per legal opinion is given by the legal expert only Miller, this tender has been passed in favor of the
May I respond?
Yes, sir.
This is perhaps the last judgment I'll be referring to. Only to answer this particular point, my lord. Kindly, my memo of citations may be seen. I will not trouble this court with any further judgment. My memo of citations that was just referred to previously. Near Development Authority was the first.
Yes, sir. Mirror Development.
Near Development was the first case. This time I'd like to read the last case, that is page number, case number 5, AG Construction.
Constructions, para number 26.
104 page number, it starts.
Para number 26.
Para number 26 is relevant in this.
Yes.
I have stated this in the writ affidavit, but
yes, sir.
But before reading that particular paragraph, Lord, my argument, Lord, and I've stated this in the writ affidavit also, that Mars Engineers and Erectors Partnership Firm once existed long back, about 7 to 8 years ago, 2016 and before. Thereafter, it lapsed, it went defunct, it did not execute any works of this nature. The person, that is the sixth respondent, started certain financial ventures in the district of Khammam and lost some money. And then he has struck this position with the fifth respondent and re-entered the arena in BTPS for the first time. With this new sole proprietorship is my argument now. In that context, dealing with the Honorable Supreme Court's New Horizons judgment, the Honorable Punjab and Haryana High Court states on page number 117, page number is at the bottom, 117, just above paragraph number 27, from therefore in reference to. The rest of it may not be really relevant. This is the 8th line from the top. Therefore,
yes.
Therefore, in reference to the decision in New Horizons Limited, the High Court held that requirement regarding past experience had to be considered from the standpoint of the prudent businessman and commercial point of view. Thus, the corporate veil was required to be lifted to find out the persons who were in actual control and behind the company. Again, what we wish to lay emphasis upon is that there was a complete takeover of the firm, along with its assets and liabilities. No portion or remnants of the experiential contribution that created the experience of the erstwhile firm was lost or left behind on its transition from being a firm to becoming a company, insofar as the conglomerate of individuals behind the rail remained the same. In this case, my lord, there is no such transition. The work is ancient, my lord. It is a decade old. And once that has lapsed and the firm has went defunct, he suddenly re-enters in collision with the fifth respondent. I countered that in my very writ affidavit. I stated these facts, my lord. I cited this judgment in my writ affidavit. I did not suppress it.
Yes, sir.
Therefore, there is no transition, my lord.
Yes, Pawan.
Yes, sir.
Yes, sir.
Sorry. And there is no transaction is not the article stated over here in this first period. These are the
What is it?
Lordships, I'm a detailed counter.
That's fine. I come back in arguments for both the repetitions separately, but the subject is the same.
Let him file the documents first. Put some date first.
Written arguments, I can find them tomorrow.
Let him be next week also. I will come.
But it can be resolved. But in that case, I-
20% వర్క్ కూడా అయిపోతుంది అతను పైన